May I please your lordship? My lord, item number 20, my lord. I am for a respondent, my lord, Union of India, my lord. Directed to produce record, my lord. Record is not received, my lord. I have taken consent of the other side, my lord. Dismissal. Other side, I am Dr. my lord. Yeah. I've taken.
Achha, what do you want?
This some time may be granted, my lord, from at least my lord, 4 weeks, my lord.
Mr. S.K. Medi, learned CGC submits that records will be necessary for conducting the hearing of this case. However, he is yet to receive the departmental record. As such, 3 weeks further time has been prayed for producing the record. Since the prayer is made with the consent of the petitioner's counsel, the same stands allowed. List the matter accordingly.
Date may fix, sir. Yes,
After,
yes.
in the new year.
Yeah,
Yes.
yeah.
My lord, this matter relates to family pension, my lord, and the petitioner is bedridden now, my lord. So it may be listed next month.
Second week of, sorry? Next month.
Next, my lord, on
Second week of December.
Yes.
Second week of December.
Second week.
My lord, I wish to mention item number 16, my lord. My lord, matter may pass over for today, my lord. Item number 16, my lord.
On the request of Mr. Alan Dehingia, learned counsel for the, why you want, it is the 2015 matter?
Your lordship, my lord, the next week, my lord, any date, my lord. Today, my lord.
Can't be guaranteed. On the request of Mr. Alan Dehinga, learned counsel for the petitioner, seeking adjournment of hearing of this case on personal ground, the matter stands adjourned for 2 weeks. List accordingly.
May I please, your lordship. My lord, I have a prayer for listing of a case, my lord, in the second week of December, my lord. Matter pertains to, my lord, selection and appointment to the post of Revenue Solicitor in the office of District Commissioner, my lord.
Second week.
My lord, I'm deeply obliged. My lord.
No, please, your lordship. I want to listing the matter 2018 matter. It's a pension matter, your lordship. Matter may fix on next Tuesday.
Second week of December.
So much.
May I please, Lordship? Lordship, the matter was dismissed on default on 9/11/24. Thereafter revoked on my application. It may come up on the first week of December at any date, Lordship.
You have filed IA.
I have filed and restored it.
Second week of December.
Lordship, I have another petition, a prayer of similar nature.
Yes. What is it?
This is about the dismissal of service,
Second week of December.
Lordship.
May it please your lordship. So with the consent of the other side, I beg to mention item number 5 of today's daily list. I am appearing on behalf of senior counsel Mr. P.K. Tiwari, who was unable to appear due to some personal difficulty. So the matter may kindly be adjourned for the day.
A request for adjournment has been made in this case on behalf of due to non-availability of Mr. P.K. Tiwari, learned senior counsel, who has been engaged in this case to argue the matter. Since the prayer is not opposed, same stands allowed. List again after 3 weeks.
Highly obliged.
May I please, your lordship, one pending petition that will be listed for withdrawal, lordship.
When do you want it?
Next week, any day, lordship.
Withdrawal, you can get it tomorrow also, no problem.
Lordship.
Yes. Tomorrow.
May I
Please, lordship. I beg to mention for listing and revision of the family pension matter, lordship. Second week of December.
Third week of December.
But I beg to mention for listing of a matter, my lord. Matter relates to reinstatement of service, my lord. My lord, can it be listed tomorrow, my lord? Urgency.
Second week of December. Yes, next.
My lord, day after tomorrow is fixed for cross-examination, my lord. Earlier also, my lord. He was actually suspended in the year 2023, my lord. He had,
So what is the problem?
my lord, earlier also we have filed a writ petition, my lord, before this.
You
My
have filed
lord, directed.
petition when?
Earlier writ petition is disposed of because on the ground, my lord, the respondent.
You want it for motion?
Yes, my lord. More for more.
Motion Monday.
Can it be tomorrow, my lord? On 30th, my lord, date is fixed, my lord. For
Monday. Motion Monday.
Your lordship, I beg to mention this writ petition for listing the second week of December for orders.
May it please your lordship. Lordship, I pray for listing of a motion matter, lordship, tomorrow, lordship, because the urgency is that, my lord, since we have lord, filed this petition, my lord, it relates to promotion of certain persons, not those belonging to the
Monday.
lordship. The urgency is that, my lord, they will be issuing the promotion orders.
We'll
Lordship,
stay
within the day.
Monday. We'll stay.
I'm highly obliged.
May I please, lordship. Lordship, I'm praying for listing this matter for admission, lordship. Can it be again in the second week of December?
What is the matter about?
Lordship, the arrear salary, concern the arrear salary.
Third week of December.
May I please, your lordship? Lordship, I beg to mention for listing a WFC, lordship. Can it be, lordship, second week of December?
What is the matter about?
Lordship, a pension matter, lordship.
Third week of December. Yes.
Of last year, lordship.
Lordship, this case is measured punishment, and 6 months have elapsed since the last date was there. We have already filed. A respondent has already filed a affidavit, and rejoinder affidavit has also been filed 6 months back. So we want a date for orders.
When do you want it?
If it's 6th is given, it will be 6th.
May I please, your lordship, with the consent of other side, lordship, item number 6. Here, lordship, yesterday I have received the records, lordship. We have agreed with the date on 7th of January, lordship.
Mr. SS Royal and CGC submits that the departmental records have been received by him only yesterday, and therefore the writ petition be fixed for admission hearing in the first week of January. The prayer made by Mr. Roy has not been opposed by learned counsel for the petitioner, Mr.
NK Sharma.
NK Sharma. In view of the above, register to list this case again on 7th of January 2024 as a 2025 as a fixed date.
Oblige, lordship.
May I please to Lordship, I beg to mention for listing Lordship, matter pertains to family matter, family pension Lordship.
Well, second or third week of January, you choose.
Daily list for admission item 1.
May I please the lord? My lord, in this writ petition, my lord, we have challenged, my lord, order of, my lord, demotion from, my lord, the post of head assistant to the, my lord, lower divisional assistant, my lord. My lord, I was appointed as junior mohorer, my lord, under the Sipsagar Municipal Board, my lord, annexure 1 at page 19, my lord.
What is the point involved?
Lordship.
What is the point involved?
Lordship, without issuing any so-cause notice, any departmental inquiry, nothing, my lord. I was demoted, my lord, not only, my lord, from the head assistant to the upper divisional assistant, but to the post of, my lord, lower divisional assistant, my lord. Whereas I was promoted, my lord, after approval of the, my lord, the managing committee of Sipsagar Municipal Board, my lord. My lord, your lordship may see the annexure, my lord, annexure 8, lordship, at page, my lord, 38, lordship. Shri Hemanto Sangmai, head assistants of the Sipsagar Municipal Board, Sipsagar is hereby sanctioned pay scale of rupees so-and-so and revised pay scale structure plus annual DA as admissible as per government rule with effect from 15 February. It was, my lord, after I have been promoted to the post of, my lord, head assistant, my lord.
Where is the order of promotion?
My lord, that was, my lord, at page 35, my lord. Annexure 7. In the interest of smooth functioning of Sipsagar Municipal Board, Sri so-and-so UDA has been entrusted with the charge of head assistant with immediate effect. The order passed by letter number so-and-so entrusting so-and-so with the charge of head assistant is hereby revoked. Be it mentioned here that Sri so-and-so and so-and-so will continue their service as UDA. Sri Vijayadatta is entrusted to hand over the charge of head assistant to Sri Hemanto Sangmai. He is the petitioner.
But this is not the order of promotion. This is only charge.
Lordship.
Then?
In fact, lordship, when, my lord, I have been promoted to the, at least to the post of UDA, my lord. That was that promotional order, your lordship will find, my lord, at lordship, at page 33, my lord. As per resolution number, may I read, lord? Page 33.
Yes.
As per resolution number 4A adopted in the meeting held on so-and-so, in the conference hall of so-and-so for discussion of the tax matters, Sri Hemanto Sangmai LDA has been promoted to the UDA with effect from 1/1/2020, lordship. So, my lord, I was initially appointed in 1995. After 25 years of service, I was promoted to the post of, my lord, UDA, my lord. My lord, now what they are not only, my lord, demoting me from head assistant to the, my lord, UDA, but they have also demoted me to the, my lord, post of, my lord, LDA, my lord.
Where is the impugned order?
Lordship, impugned order is at page, lordship, 41. Page 41, lordship. With reference to the subject cited above, you are hereby informed that in course of discussion held by Administrative Committee on so-and-so in the conference hall of Sipsagar Municipal Board, several irregularities have been noticed in your service career. It has been noticed that even after receipt of notice to the effect that as per government notification number so and so dispur 17/12/16, no employee gets promotion, appointment, regularization of service without preparation of staffing pattern. You have been promoted to LDA, UDA, White memo number so and so without taking approval from administrative committee. It has also been noticed that after 2 days of passing the aforesaid order, that is on 15/2/2020, you have been again promoted to the post of health assistant, White order number so and so, without taking approval from administrative committee and violating provisions of FRBN Act 2005. You have been given salary in the pay scale of head assistant as per Gov notification memo number so and so under secretary to the government of Assam Finance Department. It has been noticed that the office has been misled by keeping the undersigned unaware about the issuance of notification by the Gov, restraining promotion, appointment, regularization of service of the government employee. In such a situation that the employees who are senior to an experienced than you are working and they have got promotion, you have been drawing salary in the pay scale of head assistant as per order number so and so without fixation of any pay scale. On 13/2/2020, the services of all Assam municipal employees has been regularized by the date 4th September 2013 was fixed as cut-off date, and after the said bill was adopted by the assembly, the bill was published in the Gazette notification with governor's signature, and thereafter all the municipal employees are included under the Department of Town and Country Affairs. However, it has been noticed that you were promoted to the following year and paid salary in the pay scale of head assistant, which was a violation of Gazette notification. This act committed by you has violation all the government service rules. Therefore, as per unanimous resolution adopted in the meeting of the administrative committee, you are demoted from the post of head assistant to the post of LDA, and you are asked to return the excess salary that you have already drawn as head assistant in the fund of municipal board. You were also asked to hand over the files and keys of alumnus to the so and so immediately with receipt of this order.
So now your client is working as what?
My lord, as LDA lordship.
As LDA.
Lordship. Yes, my lord, I was promoted, my lord. It's a promotional order, my
All
lord.
right. Now, what is the affidavit? Who has filed the affidavit?
My lord, they have filed the affidavit. My lord, they have projected
No,
the case.
Mr.
Lordship. Lordship.
There is nothing called they. Which respondent has filed affidavit?
Respondent number 5, my lord.
Say that. 5, not even 5, 5 and 6.
5 and 6, my lord.
Who is respondent number 5? Who has sworn the affidavit?
My lord, he is the executive officer, my lord.
So what is their stand in the affidavit?
My lord, now they have projected the case, lordship, that my promotion to the post of UDA, my lord, that was made after 25 of my service. They have said that it was not a promotion, it was an appointment, my lord. My lord,
where is that statement?
My lord. Not at page lordship, running page 49, para 4. Para 4, second sub, my lord, I am.
Yes.
That with regard to the averment made in para 5 and 6 of the petition, deponent denies the same. It is denied that the resolution number so and so, the petitioner was promoted to the senior grade. In this respect, it is stated that by resolution number 4 of 6 so and so, it was decided to appoint the petitioner in the vacant post of upper divisional assistant and also to allow him to work under the head assistant so and so. It is, however, contended that while appointing the petitioner against the post of UDA, the instruction guidelines order received from the government of Assam from time to time, more particularly order number so and so dated 11 December 2016 as well as so and so, was not taken into consideration by the then Sipsagar Municipal Board as appeared from the resolution number so and so. It is to be mentioned that by the forces communication made to all the urban local bodies, government of Assam put ban on fresh appointment, upgradation, regularization of municipal employees till finalization of the staffing pattern by the government of Assam. Thus, there is apparent violation of Gov guideline order in passing the resolution number 4A of so and so, appointing the petitioner in the vacant post of UDA. That apart, no selection process held and approval of administrative committee was not obtained prior to giving appointment of the petitioner against the same post of UDA. My lord, they are saying that it was not in my lord promotion, it was in my lord a fresh appointment, my lord, after 25 of my service as LDA, my lord. And that notification which they have referred to, my lord, they have annexed, my lord, page 58, lordship. It refers to only fresh appointment, my lord. It's nothing to do with the promotion, my lord. page 57, my lord, annexure A to their affidavit. This has referred to the Urban Development Department letter number so and so that has put a ban on fresh appointment in municipal boards and town committee. It has been observed that some municipal boards and town committee are moving government for obtaining approval for making fresh recruitment, engagement of personnel in municipal boards, town committees. Please clarify
And
that.
what is the rule, under which rule he is entitled to be promoted from UDA to LDA, LDA to UDA?
My lord, that is as per the, my lord, some service, my lord, disciplinary rules, my lord. My lord, lordship, I'm sorry, my lord. That is, my lord, the some service rules, my lord.
Which rule?
Lordship, that, my lord, I'm little, yeah, lordship. Otherwise, my lord,
You
under
have to
this
show to the court that his promotion was permissible under the rules.
lordship. Otherwise, my lord, there is no allegation, my lord, nothing, my lord. It was promoted as per the resolution
I
adopted.
have understood,
Lordship,
but
lordship,
you may be right in that.
lordship.
His UDA position appears to be pursuant to a promotion,
Lordship,
but promotion is a creature of a statute
lordship,
or a rule.
lordship,
So you have to show the court
lordship.
which is the rule which permits the promotion of LDA to UDA.
My
Prima facie case
My
has to be made out, isn't it?
lordship, lordship,
So where is that? You have not come prepared.
lordship. In fact, it's a new subject for me, my lord, service matter.
You know,
Some time maybe granted.
which is a comfortable subject for you?
My lord,
Tax.
taxation, lordship.
GST. So to write out a judgment, I will need this
Lordship,
information.
lordship.
You may have a case, but then, yes, what is this?
Lordship, in this case, Lordship, what happened? Rightly or wrongly, there is a
You
resolution
are appearing for whom?
for Chipsaga Municipal Board, Lordship.
Hmm.
Lordship, rightly or wrongly, there is a resolution in favor of UDA, Lordship. That too, if we go the resolution, Lordship, page 33,
There is a
Lordship.
resolution in favor of?
Petitioner, Lordship, page 33, Lordship. But that resolution also not the word, promoted word was used, Lordship. Page 33,
No,
Lordship.
but he's saying you should have given him a notice. You've given him a
That
promotion.
part, I must agree, Lordship, so far as that UDA is concerned. But he is claiming the post of head assistant. What happened, Lordship? He
So
was,
head assistant is not a promotion.
he is not
That
promoted.
we'll observe.
And moreover, Lordship, he is enjoying the scale pay of head assistant. It is illegal, Lordship. If any illegality is crop up in during the process of
No,
official.
no, what the court is thinking is that until and unless that order of promotion at page 35.
Page 33, Lordship, prior to that, Lordship, resolution, may I read,
Yes.
Lordship, once again?
Yes.
At the, Lordship, got it? At the
Yes.
beginning of the discussion on the other matter, when Honorable Vice Chairman raised the issue of head assistant,
You are reading from which page?
page 30, Lordship.
Yes.
At the beginning of discussion of other matter, when Honorable Chairman raises the issue of head assistant, the Honorable Chairperson mentioned that current head assistant Shri Aishun Begum will retire in the month of November. Then Honorable Member of Board number so-and-so has opined that one of the employee of the board should be given opportunity to learn the necessary work, whereupon Honorable Member of Board number so-and-so mentioned that Shri Hemanta Sangmai, LDA of the General Bus may be selected for that purpose. Then the House discussed the matter and approved that Shri Hemanta Sangmai should be promoted to the post of UDA, which is currently lying vacant, enabling him to learn the necessary work under the head assistant. But in the vernacular, Lordship, in the next page, here, the খালি থকা উৎসৱক সহায় কৰি হেমন্ত চাংমাই নিয়োগ কৰি মুখ্য সহায়িকাৰ অধীনত কাম কাজ শিকাৰ বিষয়টো অনুমোদন জনায়। The process of promotion, Lordship, should be approved by the express section.
That's all right. As far as head assistant is concerned,
Lordship,
that the court is not recognizing any right in this regard.
Even, Lordship, for the post of promotion also, was not promoted by this order, Lordship.
No, no. What about UDA, LDA to UDA?
Yes, this is even UDA also. He referring to that resolution, Lordship, 4A, page 30. Even though he used the word promoted, but in vernacular, there is no padunnati. This is new to just the entrance fee.
This is the translated copy, page 33.
Page 33 was order issued by that. It is a
No, this is the translated copy. My lord,
I am referring page 31, Lordship, page 31, the original resolution.
Padunnati.
Yes, but original resolution is page 31, Lordship.
That is a different matter.
Page 31, Lordship.
But for his purpose, what is relevant is.
But he is annexed page 31 also.
My
So,
lord, may
Yes, I got your point, Lordship. But for that, I am fairly concede that for that he is entitled to a notice so far as page 33 is concerned. But he is enjoying after that order 13/2/2020, within 2 days he has issued another order. 15/2, Lordship, page 35. Without any resolution, without anything, Lordship, he is enjoying the pay scale enjoined to the head assistant, which is a promotional.
So we'll say his right till the matter is finally decided
Lordship,
after issuing notice,
Lordship.
his rights and privileges attached to the post of UDA shall be
Lordship.
protected.
Lordship,
Not
in
head
fact, my
assistant.
lord.
Yes.
Lordship may see page 34, that is the vernacular
So what
version
is
of
the point you're trying to make?
My lord, this is the, my lord,
A head
promotion.
assistant, you will not be protected.
Lordship. Otherwise, my lord,
UDA.
UDA, from LDA to UDA, it was promotion. My lord, may see the order, vernacular.
That,
portion,
Mr.
page
Chetla, you have not heard, I have mentioned it.
Lordship, deeply obliged.
I am also considering that part, Lordship.
Hmm.
That for that he is entitled to a notice so far as his demotion from the UDA to LDA is concerned. But so far as head assistant, Lordship, it is a promotional post without any resolution, without any exercise. He is just only getting a pay benefit of a age. And we can recover it, Lordship, as per Rafik Masi also, Lordship.
The law will take its own
Lord, to
course.
take our own course.
But if he has discharged his duties as head assistant, rightly or wrongly, even on temporary basis,
Lordship.
for that period, he will be entitled to the.
Lordship, he was
But
the
that is another matter.
Lordship.
Just for you both to sort.
He
it.
was the instrumentality of passing off that impugn order, Lordship, of that benefit illegally, Lordship. We can
Heard
recover.
Mr. Sitial and a counsel appearing for the writ petitioner. Also heard Ms. M. Bhattacharya, learned additional senior government advocate Assam, appearing for the respond numbers 1 to 4. Mr. P.P. Datta, learned counsel, has appeared for learned standing counsel Sivsagar Municipal Board, has appeared for the respond numbers 5 and 6. Stop. By filing this writ petition, the petitioner is assailed the order dated 10/6/2022, issued by the respond number 6, cancelling his promotion to the post of UDA and thereafter his appointment as head assistant of the Sibsagar Municipal Board and reverting him back to the original post of LDA on the ground that the entire process was visited with complete irregularities. Visited, huh? Stop. The primary ground of challenge made to the impugn order dated 10/6/2022 is that the order has been issued in utter violation of the principles of natural justice. First of all, the facts of the case, in a nutshell, is that the writ petitioner hearing was appointed as a LDA, lower divisional assistant, bracket LDA, under the Sibsagar Municipal Board way back in the year 1995. Was full stop. While serving as an LDA under the board, the petitioner was promoted to the post of UDA in deference, DEFERENC, in deference to resolution number numerical 4, bracket capital A, bracket close, adopted in the meeting of the board held on 28/8/2019 in the conference hall of Sivasagar Municipal Board. First up. Thereafter, board wide order dated 13/2/2020, promotion order 2. Thereafter, the writ petitioner was allowed to function as the head assistant. Where is that order, head assistant?
Lordship, at
Page 36, 35.
35.
Head assistant. Now, thereafter, the petitioner was entrusted with the charge of head assistant with immediate effect. Wide order dated 15/2/2020. Full stop. It is apparent, 15/2/2020. First, subsequently, the respondent number 6 had issued the impugn order dated
Page 41.
10/6/2022, cancelling the charge assigned to the petitioner in the post of head assistant and also his promotion to the post of UDA and reverted the petitioner promotion given to the petitioner to the post of UDA by order dated 13/2/2020 and reverted him in the post of original post of LDA. Full stop. That apart, a direction was also issued to recover the excess salary which the petitioner had drawn in the post of head assistant. Full stop. The promotion given to the petitioner from the post of LDA to UDA was apparently interfered with on the ground that the same was issued without obtaining administrative approval from the relevant committee. Full stop. Next
Government
paragraph.
guideline.
Huh?
In violation of government guidelines.
And in violation of the government guidelines. Full stop. By referring to the government guideline, it appears that the respondents have relied upon the order dated 17/12/2016 issued by the Secretary to the Government of Assam from a Urban Development Department, which had made it mandatory for the municipal boards and town committees to obtain prior approval before making fresh recruitment stroke engagement of personnel in municipal boards stroke town committees. First step. By referring to the materials available on record, Mr. Chetia, learned counsel for the writ petitioner, has argued that the circular dated 17/12/2016 is applicable in case of fresh recruitment and the same did not have any bearing in the case of promotion given to the internal departmental candidates. First, that apart, submits Mr. Chetia. Even assuming that there was any valid ground for the respondents to issue the impugn order dated so-and-so 10/6/2022, the petitioner ought to have been given an opportunity to show cause before reverting him 2 stages, that is from the position of head assistant to the position of LDA, thus adversely affecting his interest in the matter. On such ground, the learned counsel for the petitioner has made a request to set aside the order dated 10/6/2022. Full stop. Next, responding to the above arguments, Mr. Datta, learned counsel for the respondent numbers 5 and 6, has argued that the procedure adopted for promoting the petitioner from the post of LDA to UDA was not in accordance with the mandate of the rules or the guidelines laid down by the government of Assam. Full stop. That apart, submits Mr. Datta. Within 2 days from his promotion to the post of UDA, the petitioner was asked to discharge the function of head assistant. That too, by giving a go-by to the requirements of the rules. Therefore, there is no illegality in the impugn order dated 10/6/2022 issued by the respondent authorities. Full stop. Mr. Datta has, however, submitted in his usual fairness that since reversion of the petitioner from the post of UDA to LDA would have adverse consequences upon him, the authorities were obliged to serve a show cause notice and hear the petitioner before issuing such order. Full stop. I have considered the submissions made at the bar and have gone through the materials available on record. The basic facts, as noted herein above, are not in dispute, full stop. What is apparent from the materials on record that the petitioner was promoted from the post of LDA to the post of UDA on 13/2/2022 in terms of resolution number 4 bracket capital A bracket close of the Sivsagar Municipal Board. However, there is nothing to show that the petitioner was ever promoted to the post of head assistant, full stop. Rather, it appears that he was only asked to hold the charge of head assistant, which was apparently a temporary arrangement, full stop. In that view of the matter, no substantive right of the petitioner in the post of head assistant can be recognized by this court in the facts and circumstances of the case. However, the same cannot be said with regard to the promotion of the petitioner from the post of LDA to UDA, which appears to be a regular promotion given effect to based on a resolution adopted in the meeting of the board, full stop. If such order of promotion is required to be revoked and the petitioner is required to be demoted to the post of LDA. Now, if such order of promotion is revoked and the petitioner is demoted to the post of LDA, for whatever may be the reason, it would certainly have adverse civil consequences on the petitioner. Full stop. Under such circumstances, if the order is passed, order of demotion is passed without giving an opportunity of being heard to the petitioner, the same would undoubtedly militate against the principles of natural justice, and on such count alone would become unsustainable in the eyes of law. Full stop. Having regard to the facts and circumstances of the case, and after taking note of the submissions made at the bar, this court is of the unhesitant opinion that the order dated 10/6/2022 is vitiated due to total non-compliance of the principles of natural justice. The same is accordingly set aside. Liberty is, however, given to the respondents to initiate a fresh process in the matter, if so advised, by serving prior show cause notice upon the petitioner and giving him an opportunity of being heard in the matter. Full stop. It is also made clear that the right of the petitioner to submit his show cause would remain confined only to the demotion, only to his demotion from the post of UDA to LDA, and not and consequential rights attached thereto, and not to any other claim. With the above observation, this writ petition stands disposed of.
Deeply.
That impugnator means that so far as post of UDA to LDA.
That's last line is very clear. Impugnator is hereby set aside insofar as the same seeks to demote the petitioner from the post of UDA to LDA.
Deeply agreed.
I'm serving in Food Corporation of India. The matter relates to my posting as AG2 officer, assistant grade 2 officer, in low third category post in Food Corporation of India. So, as per the in the prior, to make the, my point easy, I have made a reference to the seniority list with a particular reference to a person who was just below me. That the list appears in page number
No,
20.
below you means there are three writ petitions.
There,
You are appearing in all three.
all three.
Then it's not one petitioner, you are representing three of them.
Three separate petitioners.
Correct. You are arguing which case now?
It is Ankit Kumar.
What is the case number?
Case number is 6633 6633.
What is the issue involved in these three cases?
It is seniority matter. Seniority, as per the seniority list published every year in the December, Ankit Kumar was a senior to a particular reference I am giving, Sanjay Bhushan Paul, that is there. In the year 19, he was, as on 31/12/19, he was senior. In 31/12/20, when the list was drawn, he was also, and he was shown below Sanjay Bhushan Paul, greater down. Now, the point here is that Ankit Kumar was served with a notice on 7/12/19. 7/12/19, he was 6 on 19. And on the basis of that service of notice, he was not considered for promotion. It is a promotion on the basis of seniority. He was not promoted to AG1. From AG2 to AG1, he was not promoted. And afterwards, in 2019 and 2020, he got the promotion in AG1. Now, the main contention here is that as per the list, as per the charge sheet, that is, as per the punishment order, which was issued to him on 28/2/20, the punishment order makes a reference that, sir, it is in page number 30. It makes a reference that whereas disciplinary proceedings under Regulation 60 of the FCI Staff Regulation 71 was initiated against Ankit Kumar AG2 G, then said in charge of said number 4 and 5, FCI FSD Bindukuri by memorandum number BNS 41 FSD Bindukuri dated 6/7/12/19. 6/12/19, this was the charge he was given on 7, peg end of the year, December. Now, here,
all right. Now, why these three petitions are tagged together?
Similar cases. Similar
All
cases.
seniority matter, my lord. My lord, what happened that all the three petitioners were charge sheeted, my lord, and they were imposed penalty of 1,80,000. Some were imposed penalty of 90,000. And on the before that, for the this charge was framed, my lord. JPSC has Journal Promotion Committee has considered their case and put it under the seal cover. Now, since this penalty was imposed, that was not considered. Later on the latter year, in the year 2020, he was considered and he was given promotion to AG1 from AG2 to AG1. Now he became junior to his earlier junior person. Now that disciplinary process, that disciplinary order was challenged by all the three petitioners, and it is pending for judgment, my lord. It was heard by the Honorable Justice Unnikrishnan Nair, my lord. So I say that let that the judgment come thereafter.
Oh, that matter has been heard already.
That matter has been heard.
Then you have
It is
to wait
better
for
for
the
the
judgment.
petitioner that wait for that.
Lordship,
Ultimately, in this case, we'll say that it will abide by the order passed in that case.
Lordship,
Why do you want to take that
Lordship,
chance?
I've got something to say here.
Kiraman case is clear, my lord.
No, just a minute. Let him.
Yeah,
let
yes,
him
ma'am.
say. Mr. Gupta, see, your case, otherwise these cases are normally on a very short point. There was a time when departmental proceeding was initiated against your clients.
Yes.
And they were imposed with some penalty.
Yes.
It is at that time the promotion process was going on. I've not read your brief, but by listening to both of you,
yes, sir.
tell me if I'm correct in my understanding. So they kept the consideration of your clients in a seal cover.
Yes.
And after the penalty was imposed, the promotion was not given effect to. Obviously, if there is a penalty, then it will have some repercussion. Now, subsequently, your clients have been promoted
Yes.
from AG2 to AG1.
Yes, sir. Lordship.
But the seniority position has been disturbed. Your
Disturbed.
juniors have gone above you. You want now that your position should be restored
Yes, sir.
above your seniors.
Yes, Lord.
If the penalty order is interfered with, you may have a case. If it is not interfered with, you will not have a case. So why are you rushing through it right now?
Your Lordship, my humble submission, please listen to what I got.
That's what I'm doing. What else am I doing?
Yes, yes, yes.
But
sir.
you please tell what
A
you have to say.
particular point, I'll be touching the
Yes.
point on which I'm resting the case right now.
Yes.
In page number 18 and 9,
No, forget page. You tell us what you want to say. First, tell that. What is your response to this? What I have said
I mean,
just now?
my see the government submits.
Because I am also telling you very clearly,
Yes.
if you want a final hearing, then the only judgment will be it will abide by the final order passed in those cases. You have to file fresh petition again. Do you want to do that?
No.
Then wait for the judgment.
This thing is
Be very precise and come out quickly.
The government servant to whom the sealed cover procedure is applicable is for one, government servant under suspension. Number two, government servant in respect to whom charge sheet has been issued and a disciplinary proceedings are pending. And three, government servants in respect to whom prosecution for a criminal charge is pending. In this case, when these minutes were drawn in the JPC mornings, what my learned friend was telling, when the minutes of the Journal Promotion Committee meeting held on 27/8/19 at Journal Office for drawing the panel for promotion of filling of the post of within the category 3 post was held. At the time they have mentioned that case pending, sealed cover. But at that time he was not charge sheeted. He was not charge sheeted. On 27/8 or 6, whatever is written, 2019, he was not charge sheeted, your Lordship.
That's correct. But that is the time, if you had got an interim order, it was different. Today they are penalized to get charge sheeted. They are penalized. What is the court's view on the penalty? Without getting clarity on that,
This court cannot say that it was a prejudiced.
You argue then.
A prejudiced because they were not charge sheeted. Their sealed cover should not have left. A normal case, they should have been promoted.
I'm just clarifying my
They-
point. It was a time when vigilance case was pending, my lord. Because vigilance case was pending, and then thereafter they were charged sheeted.
Case pending means that doesn't makes him eligible for sealed cover.
So is it your stand? Let's be clear first.
Yes.
That regardless of what happens in those cases, you want a verdict in these cases now.
Yes.
That is your case.
Yes.
Then it's going against you. You argue. That's the law. Can't be helped. We can't overreach the matter which has already been heard, where a penalty has been imposed. That will amount to overreaching that.
So we have to wait for the judgment.
You should have got it tagged with those matters also. Because it has got a direct bearing. That time, whatever you may have, right now, your clients have been penalized. The court cannot ignore that fact. All right, at that point of time, you may have a point, but that stage is now gone. Today, they are penalized. If their penalty is upheld, then it will have consequences on your client's interest. If the penalty is set aside, you would have an open and shut case here.
Yes, sir.
So what is there in it? It is only a question of giving effect. Otherwise, all your clients are already in AG1. Is it not?
Yeah.
So why are you risking that position for your clients by pressing these cases today when you have already argued writ petitions where the order of penalty is under challenge?
Yes.
If the order is upheld by the court, then the matter will have to be looked into from another perspective. But if it is set aside, then the whole thing will change. So if you want to press it now, this court will have no option but to say that
It's all right.
it will
That's
have
all
a
right.
bearing.
We will wait for the judgment.
You have to.
Yeah.
Otherwise, I cannot say today Because what I will say is that there was no charge sheet submitted and it was not correct. But today they are penalized. So in today's situation, we cannot ignore the fact that having suffered a penalty, how can the court say that give them retrospective seniority? How can the court say that?
Yes.
So why are you not understanding when I'm saying something? The penalty will have an effect. The court will have to proceed on the ground that they are penalized officers. And if there is a penalty given, then can they get seniority of promotion with effect from that date when the whole proceeding was in the womb and then it culminated into a departmental proceeding and order of penalty? It cannot be ignored by the court.
Yes.
You want to argue, you argue, but I am telling you very clearly.
No,
This is the legal issue.
I get,
Maybe you have not applied your mind to the legal issue. The court today cannot ignore the fact that a penalty has been imposed on your clients. Hyper-technicalities will not help always. If you had got an interim order then, that since at this stage there is no charge sheet, no seal cover, that would have been a different matter. You are arguing, your argument is based on a situation which was there 2 years back.
Yes.
Today that situation will not be taken note of by the court. So for whatever reason, by pressing this, you will be causing damage to your client's interest. That's what I am trying to point out. You want to argue, you argue.
Yes.
What do you want to do?
I agree for
You agree?
verdict in the other case to come.
If you don't agree, there is no problem. You can argue.
Yes.
But please apply your mind.
Yes.
That situation is gone. The water has flown under the bridge. You can't say that forget the penalty. Treat me as nothing against me. Impossible. Impossible. At that stage, there was no proceeding. But today, you are penalized officers. How can the court say that, all right, because there was nothing on that day? Why didn't you get an interim order on that day? That stage is gone.
Yes.
Yes or no?
Yes.
See, please don't feel inhibited.
No,
If you want to still argue,
No,
you
no,
are-
no more arguing.
I'm only pointing out what are the dimensions. You can convince the court that the matter is different. And if you want to do that, you do that. I have no difficulties. I'm ready to hear you
No,
today.
yes. But I'm not.
Correct. I'm just
I'm not moving.
giving my perspective because ultimately we are all working together to ensure that justice is done.
Yes.
So this is a roadblock, you can't help it. Your clients have suffered a penalty. So where is the question whether charge sheet was submitted or not? Today they are in criminal trials language, they are convicts. You are saying that there was an FIR lodged, no action taken, but they are convicts. They have been convicted. It's not the terminology to be used in service jurisprudence, but practically this is what it is. And you expect the court to forget all these things and think what happened at that stage and whether this should have been seal cover. That's not possible. That's not how law. What do you want, Mr. Gupta? You want adjournment in this case? You better wait. That's better.
Yes.
Otherwise, it will create unnecessary complications for your clients.
After January due vacation, ma'am.
So
Because
let him say when he wants.
the judgment is pending.
Judgment was made reserved
Judgment
when?
is reserved for last two and a half
You
months.
should have tagged these matters with those cases.
This was the first case incidentally. The other cases
you
came
should
later
have
on.
Tagged it together. No, then if both the cases were there, then you could have argued. Then you could have argued that this is wrong, so give me the benefit of that. You have separated it. Now that is an independent action. That action, if you don't succeed, your writ petitions will have to be dismissed. Question doesn't arise.
Yes.
You should have tagged it, but you have not done it. Fine. Now you have to wait. Mr. G.K. Gupta, counsel for the petitioner, and Mr. V.K. Singh, learned standing counsel FCI, appearing for the contesting parties in all these three writ petitions, have brought to the notice of this court that writ petitions separately filed by the present petitioners assailing the order of penalty imposed upon them have been finally heard and the judgments are reserved. Full stop. Since the petitioners are claiming the benefit of seniority, claiming the benefit of effect of their date of promotion from AG2 to AG1 on the premise that on the date on which the promotion process was going on, there was no charge sheet submitted against the petitioners, and therefore their cases could not have been kept in the seal cover on the relevant date. However, the fact remains that the petitioners, all the three petitioners have eventually been, all the three petitioners have been departmentally proceeded in respect of the charges submitted against them, and all three of them have been imposed. Is it major or minor penalty?
Minor panel.
A penalty. Full stop. Therefore, this said aspect of the matter would apparently have a relevant bearing in appreciating the contentions made by the petitioners' counsel in this batch of writ petitions. Under the circumstances, this court is of the opinion that the judgment in the other three writ petitions would have a relevant bearing in the present matters. So at this stage, Mr. Gupta submits that these writ petitions be therefore posted again in the third week of January, awaiting the verdict in the other three writ petitions. Prayer allowed that these matters be listed again in the third week of January. You want a fixed date? Do you want a fixed date?
Fixed date, if it given, it will be good.
What date you want? 21st of January? 21st of January 2025. This taken on 21st of January. Yes.
Obliged.
There is a judgment which
Yes,
please
yeah,
check out.
I'll take it.
These are not going to be very, very mechanical. Substantively, court will see.
Yes.
Item 7.
May it please your lordship. This is a matter where we have challenged the order of promotion to the private respondent number 8 and 9. Now, the ground of challenge is the seniority list and their inclusion in the seniority list could not have been done because there is a guideline of FCI which says that for these are basically handling laborers promoted to the post of Mandal in the food storage depot of FCIs. Now we are concerned with the food storage depot of Hosai. Now every depot has their own original laborers, and there are other laborers who comes to that depot. Now the guideline says those laborers who would be transferred from other depot, there will be a separate list for them, separate seniority list. And on that separate seniority list, separate promotions will take place. Now the issue herein is that we or the petitioner herein belongs to that original, he is the original incumbent of that depot. So in that particular list of original laborers, the names of the private respondents 8 and 9 have been included. Though, however, it's an admitted case of FCI that they belong to a different depot, and therefore, as per their guideline of 2016, there has to be a separate seniority list for them. Now, the interesting aspect is that in this entire depot, there has been separate seniority list for all other laborers coming from all other depots. Only for these two incumbents, they have been brought in and shown to be original laborers of that Hosai depot. Now, it is even admitted by FCI in their affidavit saying that, yes, we have done it. Now, they give two grounds for that. Number one is that they came to this depot because of not on their own request, but for administrative reasons, which the guidelines do not say so that it can be done. And number two ground that they have taken is this provisional seniority list was in circulation at earlier point of time also. You had never objected to that. So therefore, once the inclusion is there, now when these promotions are taking place, now at this time you cannot raise an objection. So it is otherwise admitted that they belong to a different depot. They have been transferred to the Hosai depot, and therefore the guidelines provide that there has to be a separate promotion seniority list as well as a separate promotions for them, which they are doing for all other employees, and I can show it from our record itself. I have brought all those annexes to show. So basically, this is the contours of this entire case. They have done a illegality and they are defending it on the ground, saying that this was done on an administrative basis and because you had never objected to that. if I may just place those documents, everything will be clear, Lordships.
Just 1 minute, just.
Yes, Lordship.
So you are the original handler.
We belong to the original depot.
How many,
handlers.
how many petitioners?
One petitioner, Lordship.
You are the indigenous, they are the migrants.
They are the
That's
migrants,
your
yes,
case.
Lordship. And their rule says migrants will have a separate list, which they are doing it for migrants of all other depots, barring these two private respondents only. Promotions, I'll show the promotions orders for other depots also. Separate list, they have separate list. FSD Hojai has got separate promotion list for all other migrants coming from all other depot. But only for these two private respondents, this special privilege for them, and thereby depriving my promotion to the post of Mandal, because I fall down 2 places. Had I not fall down 2 places, I would have been within that. There were 5 promotions taken place. I would have been among them. I would have got the promotion.
So is he likely to get promotion soon?
No,
Huh?
I mean, the post is, there is only one post of Mandal in every depot. The seniority list is prepared on the basis, it is a depot-wise seniority. Earlier it was gang-wise seniority. Now it has been made depot-wise after issuing section 9A notice. Because if we have to go by again gang-wise, the formal notice under the Industrial Dispute Act has to be given. Then there is a procedure laid down. So from long back, the seniority list is prepared on the basis of depot-wise, not a gang-wise. Gang-wise was earlier. Now, if you have to go back again depot-wise, then for again procedure, there is a procedure under the industry. We cannot go straight away.
So this depot-wise system was resorted to since when?
The depot-wise system since
Mr. Sharma,
Yes,
I'll
Lordship.
hear you. Please take your
Yes,
seat.
Lordship.
Just getting your
2006.
2006.
Yes, I have annexed that, page 163.
So as per depot-wise, they will be clubbed.
Club, and there is a 3 list, 3 years. And they were asked if you have any objection, they given in writing that we have, I have annexed that. You will kindly have a look.
So when was the first provisional list published?
My lord, I
Depot-wise?
have annexed that, my lord, at my, if lordship take up my affidavit in opposition.
No, I'm not hearing you now.
Oh,
Just give
Lordship,
us the facts. Yes.
First, the seniority list was prepared, Lord. In 2000. 2021, 2020, where the private respondent were placed at serial number 8 and 9, and petitioner was placed at serial number 14. And 2021 again, the private respondent were placed at serial number 7 and 8. Petitioner was placed at 14. And 2000 last one, a private respondent, my lord. 2023 again, the private respondent 7 and 8, 2 and 3, petitioner number 8. All the time, my lord, they have.
You have not answered the question. I'm saying, when was the first conjoint list published?
But it happened like that. The private respondents were in a different place, my lord, a depot. Earlier, there was no provision for transfer of the depots. When they were transferred, the transfer condition prepared, the existing service condition will not be disturbed. No, their career progression will not be disturbed. They came in this group. And the seniority rule says it must be depot-wise. They were placed in order of the date of appointment. The private respondent were appointed.
When was the petitioner appointed?
The petitioner was appointed on 18/12/1995, and the respondent number 8 was appointed on 4/9/1993, and respondent number 9 was appointed on 22/6/1994. So the petitioner was junior. On the basis of date of entry into service, the seniority list is prepared. Now, if the arguments advanced by Lord Fat is accepted, that if anybody is appointed today, even, and my man appointed long back is transferred, he will go back. Every time he will go.
All right, we will come to that. Now, the The contentious issue is promotion to the post of Mandal.
Mandal, there is only one post
So that one post is to be filled up
on the basis of seniority.
seniority of all the depots.
No, no, on the particular depot. On the particular depot, there are various depots. Particular depot, in depot there are gangs. They say that it should be gang wise. Depot wise, seniority is
Very,
depot.
very frightening expressions. Gangs.
Lordship.
Gangs of Wasipur.
The gangs, right. In FC, there are gangs, and one Sardar, one Mandal, and 12.
This is practically a gang war.
A gang war, particularly a gang war.
Only one thing, he's saying there's only one post of Mandal. The improving order of promotion page 76 will indicate there are various posts of Mandal. In fact, five promotions. Yes, Lordship. Yes, Lordship. Now, as I was placing before Lordship, now there are multiple posts of Mandal.
No, you start from the beginning. Who are you? What is your
Yes, Lordship. Yes, Lordship.
locus?
Yes, Lordship. First of all is that the admission part, it is already admitted that these private respondents have come from a separate depot from Silson. It is in their affidavit also of FCI that the private respondents have migrated from separate depot, and the depot is Silsar depot. This is the admitted portion. I'm just placing what is admitted for Lordships. The second thing that is admitted is the rules.
Migrated from Silchar to where?
Silsar to FSD Hojai. From Silsar, whatever. It's now presently they are in Hojai. Food storage depot, Hojai.
They have migrated from Silchar to
Tinsukia,
which
Lordship.
FSD?
Tinsukia, Lordship.
You
Yes,
said
yes.
Hojai.
FSD Tinsukia to FSD Hojai, Lordship.
Correct.
Yes, Lordship.
So FSD Hojai has a list of seniority.
Hojai has a list of seniority. They call it the
FSD
original
Tinsukia
list.
has a list of seniority.
Yes, Lordship.
FSD Silchar has a list of seniority.
Yes, Lordship.
What they have done is they have gone for a fusion. All the depots, they have clubbed the.
No, they haven't done that. This submission is coming for the first time, but that is not what the records would reveal. I'll just place that, Lordship. They have not done that.
You got the records, Mr. Rajan.
I have brought all the promotion orders that have taken place in FSD Hojai. Lordship will see how they have kept it demarcated. I'll show that.
Records will not there. I'll have to.
So records are not required. I have the documents with me. I'll just place them.
The records are not seen, then it will go against you. So we'll proceed without the records. Because the court will have to see whether their procedure is borne out from the record or not. A judgment cannot be given only on your submission.
Yes, that is true. But since it is already admitted position, and since I can show the separate promotions that have taken place in FSD Hojai vis-a-vis the migrated laborers, that would indicate that this is the
That
process
would
that
have
will follow.
nothing to do. The court will see what is the fundamental norm, what is the procedure adopted.
Yes,
Just because one promotion has happened here and there.
No, not
there
one.
can be a
Entirely in the depot, there has been like 7 to 8 separate promotions taken place.
All
to
right.
the
So you are
post of
saying
Mandal.
records are not necessary. Is that your submission? You can make that submission.
I'm not 100% sure that records would not be necessary at that point of time, but my limited understanding today would
It's all
be,
right.
if I may place the facts, Lordship will appreciate
But
that.
I'm not keeping it part-hard. This bench is there next week. Well, just check out once. No, you are free to argue, but then you will have to establish the whole thing. Without the record, the court has
It's a
to
very
proceed.
small point otherwise. What has been followed for others has, however, been conspicuously been avoided and not followed in our case.
That's
It's a
nothing.
small
case.
thing, Lordship.
That's nothing case. What has been done for others, not done here, that the court can't give a
No,
verdict.
because they have done it by way of a guideline. They have followed the guideline vis-a-vis all other migrated employees only regarding 8 and 9 special privilege.
All right, all right.
That could otherwise be very apparently clear from the documents in the writ petition, Lordship. That is only my endeavor would be. And they have already admitted that they are migrated. If they are migrated, number one, if they say that they are still following the 2016 notification that says that there will be separate list, and if they still stand with the promotions that I have here in my records, in my petition, vis-a-vis the other migrated employees, then there is nothing left for them to defend. There has been multiple promotions to the post of Mandal, all separate lists for the migrated employees. If just from page 78, if a Lordship will see, page 78.
Yes.
I have annexed all those documents, Lordship.
Division bench from next to law. So we are going ahead with the hearing, but I'm not keeping this part hard because I'm just informed that the bench is not available from next week onwards.
Some next not available.
So this will not be kept part hard. There's no problem. We can finish it off today. But something is telling me that these
Only with that caveat from my side that if for records, Lordship is inclined to dismiss my matter, maybe that will be a.
I will not put it as a part hard. Because I had an inkling that this composition of the bench is changing. I will not be in a single bench from next week. So, and that could be very long. These matters. So you argue and finish it off the case.
I'll
We'll
make an
dictate the
endeavor.
judgment in the court.
Yes, Lordship.
But I'm assuming that there will be no need for record. So you will have to establish. that the case
I
is-
also believe so, Lordship.
All
I
right.
also believe so.
Proceed.
Yes, Lordship. First of all, I'm just, as I was placing, page 76 is the impugned order of promotion.
Page 76.
Page 76.
Yes.
Now, this is dated 1/5/2024.
What are promotion of?
Promotion from the post of handling laborers to Mondal in FSD, they call it FSD, that is Food Storage Depot, Hojai, page 76.
Okay.
You got that?
Yes.
Now, the respondent number 8 and 9 is serial number 2 and 3, Sibji Shah and Mangal Pandit. Now, if you also will see that line above, the following handling laborers of FSD Hojai, originally from Hojai. The point to be noted is originally from Hojai. My contention is they're not originally from Hojai. And why is this reference given in this promotion order, originally from Hojai? I'll place that. Originally from Hojai, under District Office Nagaon, are hereby promoted to the post of Mandal subject to the following terms and conditions. Now, Sibji Shah and Mandal Pandit are the private respondents who are from Tinsukia. Now, if your lordship will see, from page 78, what they have otherwise done for all the other migrated handling laborers vis-a-vis the other depot who have migrated to FSD Hojai, page 78. Same promotion orders, same promotion date is same, lordship, 1/5/2024. Multiple promotions took place to the post of Mandal.
Yes.
Now, what is the language here? The following handling labor of FSD Hojai, originally from Sinamara via Dimapur. So that differentiation or that category has been made. Under the District Office Nagaon are hereby promoted to the post of Mandal. And one Sri Nirmal Kumar Singh Mandal has been promoted. Similarly, at the next page 79, now lordship will see this is from originally from Shillong via Dimapur. What I'm indicating is there is also a seniority list. I should have placed a seniority list prior to this. There's also a separate seniority list based on which this separate promotions takes place. So this is from now from Shillong via Dimapur. Page 80, Silchar via Dimapur. 81 is the same. Page 82, again it's originally from Dimapur. These are all separate lists. And I'll show the corresponding seniority list also, lordship. Then if your lordship will see at page 84, these are the promotions to the post of Mandal, page 84. These are promotions to the post of Mandal from Guwahati, New Guwahati. In FSD, these are all FSD Hojai promotions I'm showing you, lordship. All FSD Hojai promotions, but separate promotions. This is originally from New Guwahati. So all these promotions lordship has seen have taken place separately for people who have migrated from other places, like from Sinamora, Dimapur, New Guwahati. They are separate lists. And the impugn order of promotion at page 76 identifies those promotions as people who are originally from FSD Hojai. But the admitted position is those two private respondents are not there, are not from that place. Now, if your lordship will see the seniority list, which I should have shown prior to this, that seniority lists are at page 40. 40 is the concerned seniority list where we have challenged it.
So this is for admission, okay, or final hearing?
Admission, my lord. In fact, it's for admission.
Has it been posted for disposal or admission stage?
I think so,
Is
Lordship.
there an order?
I think so, Lordship. So I'll just show the separate seniority list and then the notification. Then the notification which says that this is the procedure I have to follow.
Because the service on the private respondent was not served.
No, it's been done, Lordship.
And then it has recently been done.
It's basically a case of discrimination to which they also admit, but they are trying to justify that by saying I had never objected to this. This is their only case, Lordship.
Yes.
May I continue, Lordship? Now at page 40 is the provisional seniority list, and this Your Lordship may kindly take a note that these are still provisional seniority lists. They are yet to publish a final list. Based on the provisional seniority list only, they have proceeded to give promotions, Lordship. And the earlier list also, seniority list, where they have said we have never objected to, were also provisional lists. They were never a final list published till date. Now at page 40, if Your Lordship may kindly come. Page 40.
1 minute, 1 minute.
Yes, Lordship.
So, have you challenged this document at page 76?
Yes, Lordship.
It's
As
on-
well as the seniority list, provisional seniority list, both of them.
Where is what is the date of this document?
1/5/2024.
No, page 76 is, yes.
It's a promotion order, Lordship.
Yes.
And the promotions were based on the seniority list, so therefore I have challenged both of them, Lordship. Though it's a provisional seniority list, but they acted on a provisional seniority list itself. There is no final seniority list.
Yes.
Yeah, please. Page 40. Now, page 40 is the impugned provisional seniority list based on which the impugned promotions have taken place at page 76. Now, if Your Lordship would see, again, it is been headed, the heading is Provisional Seniority List of Handling Laborers at FSD Hojai Origin. So there has been always an identification of that origin and the migrated ones. And this is based on a notification, which I'll place now. Now, if Your Lordship will see, the inclusion of the names are there. At serial number 2 and 3 are the private respondents, and the petitioner is at serial number 7. Ram Udgar Yadav. Page 40, serial number 7. And the promotions have taken place to the post of Mandal for 5 posts, as could be seen at page 76, impugned promotion order. So had these 2 people been off the list, I would have entered that list of promotion and I would have got the promotion. That is how my locus is, Lordship. Now, as Your Lordship has seen, that I'll just place one more thing, that at the end part of this provisional seniority list, page 42, though it is in very small fonts, I may just read page 42, that NB.
Yes.
Provisional seniority list of handling laborers under FSD Hojai as on 1/3/2024 has been prepared as per the records and the standing procedures guidelines in vogue. I just placed this line to indicate that they have also stated that this provisional seniority list is based on their guidelines that is in vogue. And they do not deny that the guidelines that I'll now place is not in vogue. Because that guideline directs them to keep separate list of seniority for the origin handling laborers and the migrated handling laborers. Now I'll show from page 45 onwards, all separate seniority list for all those laborers who have come from other depots. Page 45 onwards. Page 45, provisional seniority list of handling laborers under FSD Hojai, originally from Bongaigaon. So they have their own separate list from Bongaigaon. And these are all for FSD Hojai, Lordship. I'm not placing any other FSD's documents. All FSD Hojai's documents now I'll place. Page 46, if your Lordship will see. Page 46, this is originally from Tongla, separate list. Similarly, at page 49,
So there are separate depots which come under FSD Hojai, is that?
this is a depot. FSD is a depot. Food Storage Depot, Hojai. So there is only one depot. Hojai has got one depot, and these are all the handling laborers working under that depot.
So some are from Silchar, some are from
Migrated to this as transfer, Lordship. These are all transfers. But the guidelines or the notifications of 2016 says there will be separate
No,
lists.
originally from Tongla means Tongla also has a FSD depot.
Yes, yes. From there, he was transferred to FSD Hojai. So therefore, now here, he is not assimilated into the seniority list of Hojai, the original list, but they will have a separate list. They will have a separate list so that their promotions will not be, affected. Or
That is requirement under some rules.
2016 rules,
Which is
notifications, Lordship.
Let us see which is.
Yes, Lordship. Yes, Lordship. Page 32. This is dated 12 July 2016. And the concerned clause is at page 33. And the FCI is following this, therefore the separate list. Page 33, clause 7. May I just read that clause also? As per existing instruction, workers of department and DPS category on their transfer by FCI, in the interest of administration, are entitled to get weightage of seniority at the new place. It has been decided that till further order, seniority position of group of workers of the gang transferred from one depot to the other will not be disturbed, and a separate identity of such workers will be maintained in the incoming depot so that it does not jeopardize promotional avenues of workers already working in such depot. So therefore, that classification or that categorization of the laborers coming from different depot have been identified in this 2016 notification, which even in their seniority list, they have stated that this is as per the notification. And this is not their case that this is not in vogue. This is their case that it is in vogue. In fact, they are following it for all the other laborers, as I have indicated before, Lordships. And I can continue. There are a lot of other documents also, because there are n number of laborers having n number of seniority lists. As page 49, if your Lordship will kindly see. Because Lordship had seen the promotions taking place from Dimapur. I have shown that. So page 49 is the seniority list of Dimapur. Page 49. FSD Hojai, originally from Dimapur. Page 49. These are all originally from Dimapur. A separate list of seniority. And from this list, the promotions were effected, as I have shown to your Lordships. Similarly, for New Guwahati, Lordship has seen page 84, where the promotions from New Guwahati. And at page 53 is their seniority list. So if they have seniority list for each and every employee is coming from another depot as per their guidelines, what could be the reason for making or assimilating these two individuals from Tinsukia into the original list? They could not have done that. Their only ground is they were never transferred for their own request. cannot be a ground as per the guidelines. And number two is that we never objected to it. Is there a sustainable ground that we never object to it? We having not objected, can it give us a right of waiver? And even then, those lists that they were referring to were provisional lists. Those lists have never become final lists. In fact, this list, based on which the promotions took place in page 76, was never a final list. From provisional list, they have given promotions, and we had objected to that. In February, on 8/2/2024, prior to the provisional list publication, we had objected to this.
Where is your objection?
Page 39. Page 39. I would humbly inform you that in the labor seniority list of Hojai Depot, it has been seen that junior to me, Sibji, Gang 1 and Mongol Pandey, Gang 6, whereas they are workers who were transferred from Tinsukia Depot and came to Hojai in December 2016. According to head office circular dated 12/7/16, these workers are not senior to us under any circumstances. Therefore, I request you to please promote
No,
me.
Mr. Sharma,
Yes, Lord.
tell us one thing.
Yes, Lord.
These two persons were engaged prior to you. There's no dispute about it.
Yes, yes, yes.
So if somebody is transferred from one depot to another,
Yes.
he loses his seniority.
No, he has his own seniority list. He will have
But
his own
even if
seniority
he
list.
has own seniority list, that seniority list can be used for promotion.
As has been done from page 76 onwards, Lordship has seen, for all the seniority lists, there has been separate promotions taking place. Mandal posts, there are a lot of Mandal posts. What my learned friend has submitted, there is only one Mandal post. It belies, because if you're from page 76, Lordship will see, so many Mandal posts have been filled up.
So your case is, you should be promoted to the post of Mandal.
Obviously,
Make out that case.
I would have promoted. The inclusion of these two persons in the list of seniority of the original handlers, laborers, is why I have been deprived of the promotion. Therefore, I have challenged the provisional list. They could not have been included in the list of the original handling laborers. There has to be a separate seniority list for those two handling laborers. The seniority list should have been the seniority list of FSD Hojai for handling laborers originally from Tinsukia. As Lordship has seen, has happened for all the other people from Tongla, they have separate lists. Bongaigaon, separate list. Dimapur, separate list. New Guwahati, there is a separate list. Similarly, for these two private respondents, there should have been a separate seniority list which should have indicated from Tinsukia. They could not have been included in the original list of laborers in that depot who were originally appointed there, which they have done for all the other laborers in FSD Hojai depot itself, Lordship. And their transfers were after the guidelines. So my simple case is, there is a guideline 2016 that says you have to maintain separate seniority list for the original laborers, and for all the migrated or transferred laborers from other depots, there will be separate independent seniority list, which I have also indicated before Lordships from the documents available in the writ petition to indicate that in FSD Hojai, this is the norm that has been followed. But only for these two individuals, they have been clandestinely, I may use that word, been inducted into the original list, though they do not belong to the original list. So therefore, their inclusion has deprived my promotion, because the promotion took place for 5 posts. Had their inclusions be excluded, then I come above and I get the promotion. So therefore, I have challenged the seniority list as well as the promotion, and my ground of challenge is the rules or the notification of 2016, as well as the practice that has been already been followed in the depot pursuant to that rules or a notification, which I have indicated, separate seniority lists for all the transferred employees and separate promotions for all the transferred employees. And there are many posts of bundle. It is not that there is only one post of bundle. Now, if you have seen the promotion orders, there were around 20-25 posts of bundles that have been filled up in this promotion. Similarly, had there been a separate list for Tinsukia for these two private respondents, maybe they would have been also promoted. I do not know their case. But yes, it is a fact that their inclusion has deprived me of my promotion. And that inclusion could not have been done because of the rules or the notifications and what has been practiced and followed in the depot itself, as is evident from the records.
Understood. Now,
This is my case, Lordship.
Substantiate on the second limb of your argument.
As in, Lordship.
Had they not been included, you would have been promoted.
Yes, Lordship. Yes, Lordship. If your Lordship will come to the seniority list, provisional seniority, page 40. Page 40 and page 76, if your Lordship will take both the
Page 40.
40 as well as 76, if your Lordship will just take it side by side. Just to
Go
indicate.
one by one, what is in page 40?
Yes, Lordship. Page 40 is the provisional seniority list of handling laborers under FSD Hojai origin. So based on this, promotions took place. Now, if your Lordship will see, I stand at serial number 7. And the private respondents at serial number 2 and 3. So, if 2 and 3, their inclusion being bad in law, are excluded, then I come up to the serial number 5. Now, if your Lordship will come to the promotion order at page 76.
What is the criteria of promotion?
Seniority.
So they are bound to promote as and when people come to the seniority zone.
That is how it has been done. Everyone is from seniority only. I don't think they have a different case than that. It's a seniority, Lordship. Because these are all laborers, Lordship, laborers. There is no merit as in involved there. They are lifting bags. They basically lift those food grain bags, the laborers. From there, they become a head mandal. That means they will have another 5-6 laborers under them. From mandal, they become a sardar. They will have more laborers and mandals under them. So I don't think there is involvement of merit. And I think that that's not their case also. It's seniority only. If they otherwise object to that, I do not know. Now, if you also will come to page 76.
Yes.
5 posts of mandal were filled up from the original list. So, had I been at serial number 5, which I should have been, then I would have been promoted, Lordship, in 1/5/2024, to which I have been deprived. Now, it is not a case that these are only the 5 posts of mandal that were filled up. If you Lordship will see the other pages, multiple, page 84, 6 posts. And all these promotions are 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 20, 23, 26. 26 posts were filled up from separate lists. So had there been a separate list for the private respondents also, maybe they would have been also promoted. But not at my cost, not by bringing them into my list, depriving me and giving them promotion. How can they defend this stand? And they're defending it by saying, I never objected to the provisional list which were published at the earlier point of time. Maybe or may not be, I do not know. I'm a laborer. I do not know the integrities or nitty-gritties of all those things. Today, when I'm prejudiced, I'll challenge this. And still it is a provisional list. Interestingly, still it is a provisional list. Final list is yet to be out. They acted on a provisional list. They cannot show a final list, Lordship. So this is my case. This deprivation is bad in law, Lordship. And therefore, it should be interpreted. And I should be promoted with effect from 1/5/2024. My rightful date of promotion. This is my case, Lordship.
Yes.
My lord will come to page 104, my lord, serially, the transfer order of the particular respondent number 4 and 5. 103.
103.
Serially, my lord, the affidavit in opposition filed by us. This is the order, office order, because 14/12/2016, lordship got it.
Yes.
Because earlier, as I said, my lord, there is no provision for transfer. Lordship, I'll read the order because it is necessary, because how they could be transferred and what is their right up after the transfer. But it's the Honorable Bombay High Court, Nagpur bench, based on a news item published in the Times of India regarding his wages and wages to the tune of 4 lakhs being paid to the laborers regarding PIL number so and so. After the detailed examination, the Honorable Court came to the conclusion that prima facie the work of FCI is not perennial work. Accordingly, the Honorable Court passed judgment 2011-2015, issuing directions to Government of India to decide exemption notification of FCI depot from applicability of contract labor so and so within 1 month. Denotification of the 6 depot, 6 months, phasing out the system of departmental labor as recommended by the HCL, and revision of incentive system. As regards the transfer of labor, the Honorable Court held the transfer is in incident of service and specifically directed by number so and so. We clarify the respondent number 1 food corporation would be entitled to transfer the service of departmental labor from one depot to another, subject to protecting their salary and other service conditions. Now, last paragraph, the next page is the transfer order. And last para also, it is clearly mentioned, the workers are being transferred with stipulation that their service and other service conditions shall be fully protected. Now, this is the condition of their transfer. Last line, my lord, last paragraph, last but one. At page 104. Next, my lord, this, thereafter, my lord, the page 104, my lord. No. Now, my lord, this departmental labor challenged the transfer orders, my lord, before this honorable court, and this honorable court, my lord, did not interfere with the transfer order, and specifically provided that their service condition will not be disturbed upon transfer. And if a lordship kindly have a look at page 123, which is 123, where, my lord, I read from the last 4 lines.
There is a problem with the pagination. It's not matching. Your circular of 14/12/2016 is in page 118. But anyways, you continue. Which page you are referring to?
My lord, I'm referring to the next, the High Court's order. The lordship got 105, the transfer order, the lordship seen, my lord. Transfer order, lordship seen the transfer order.
Is that page?
My lord, at page 103, I'm in my brief, my lord, there may be a mistake, my lord.
Please show it.
আচ্ছা, তারপর রেফার করুন। তারপর এখন কোড করেছেন।
Oh, my lord, it's these paginations are corrected later, my lord. That's why the mistake.
কোনটো?
It is
Office note.
118.
Office note is 103.
103 is corrected as 118, and all the pages are correct. That's why, my lord.
What do you want to do?
Now, my lord, what I submit, my lord, is this honorable court has also specifically, when the transfer order is challenged, specifically mentioned that their service condition and career progression will not be disturbed. That is the, as per the law laid down by the Supreme Court, this was referred to.
In my favor.
So after that, my lord, the lordship will have a look at that. The three provision seniority lists were made. And if your lordship come to page 138 onwards, the petitioner specifically in my page 138, there is no objection certificate in annexure F. Annexure F.
No,
to-
these are not telling, Mr. Roy. You cannot refer to any document. Either correct it or it's not possible.
Then it's better when I correct it. I cannot, my lord, this is.
Your document says something, this says something. How am I supposed to find out?
Then it's better. I correct it better, my lord. It will be inconvenient for your lordship to look into all those documents.
All right, we'll admit it and fix firm date. You produce the record and disposal on that.
Tomorrow, Lordship.
Hmm?
Tomorrow, Lordship.
Not possible. Mr. Sharma, this is not a heart-shattering matter.
No, that is true,
Don't be
but
unreasonable.
for a laborer, it is an arbitrary matter. He is not
Forget
getting
it.
promotion.
Forget it. Heard
in a new
Mr.
case.
Sharma, learned counsel for the petitioner.
Part-heard.
Also heard Mr. P.K. Roy.
Or
learned
part-heard
counsel.
also.
Part-heard, but it will be listed in March. Before that, this bench is not available. Is that okay with you? December, January, February, this bench may not be available.
3 months it will not be available.
Hmm?
3 months it will not be available. Lordship.
Most likely, that's the indication. Do you want it to be kept part-heard?
Yeah. Lordship, I wanted the quick disposal, only that, Lordship. My
No, that's
endeavor. was to
correct,
get a
but
quick disposal,
everybody
only that.
wants a quick disposal, but
Yes, I
the
understand.
pagination is not telling, he is referring
I
to
understand.
documents which are not
But
there. What
if
to do?
if I may say so off the record, irrelevant, Lordship. It's not
If
relevant.
there
to
are
this.
10 categories of urgency, you are in category number 10. Have no doubts
For
about
all
it.
petitioners, number one, Lordship.
That's right. That's right. So let's not be.
Lordship will fix
But
a date.
we'll admit it and fix it.
Lordship, admission would, admitting will be go for a hearing, then better it will be in the admission stage only then. The chances of disposal probably would be more, Lordship.
No, but what about the chances of disposal of other cases? You are only concerned about your case,
Holding the brief of the petitioner, yes, Lordship.
but that's none of our business.
I understand.
As court,
It's
as
my-
judges,
it's-
we'll have to be.
It's my duty to make a submission from my client. I'm making it, Lordship. It is for your Lordships to decide and pass an order accordingly.
What has to be done? This pagination is.
Tomorrow, if your Lordship will take it, I'll take the trouble of correcting the paginations, Lordship. I'll do it. For him, I'll do it, Lordship.
No, tomorrow it will not, because I'll not be here, my lord, tomorrow. Tomorrow I'll not be here. Next week, I have no objection, but then next week, lordships.
What, you both decide what you want to do.
Or my junior is saying at 2, if it
First,
can be taken
let
up,
it
we'll
be
do the
on-
corrections.
Let it be on first.
It's a
week.
simple case, Lordship, as Lordship has now been able to appreciate. It's a simple case.
Let it be.
What he is placing is a judgment. That judgment itself, they had referred to
Mr.
that.
Sharma, I understand as counsel, but I think you are showing it a little, taking it a little too far.
No, yes, Lordship. I understand.
See, don't
The pressure is coming from the.
start acting like the client.
I understand, Lordship.
This is a 2024 matter. I was hearing it, but there is some
Yes,
discrepancy.
No, because of this.
I'll better
ND
produce.
hearing
I'll also
took
bring
place.
the records also, my lord.
No, because of the substantial hearing took place, so therefore I was trying to insist upon your Lordships. But I leave it to your Lordship.
You argue with the wrong page number. I'll write
No,
whatever I
that would be
understand.
very,
that
that
should possibly not
not
be
be proper, my lord.
That will not be proper.
That
That I will also say it not be proper.
Then let it be, my
So
lord,
and so, so and so.
after.
During the course of hearing of this writ petition, it transpired that there are some error in pagination of the paper book filed in this writ petition, as a result of which admission hearing could not be continued in this matter. The learned counsel for the parties to therefore take necessary steps for correction of the pagination. Let this writ petition be listed for admission hearing again when? Next week?
Next week.
Yes, your Lordship.
Next week?
Lordship will not be there on the bench.
I don't know. That's what is, there's a change. So I don't
Next
know.
week.
It will be unnecessarily problematic for you.
Let it be on next week.
These part-heard matters are listed at 4 o'clock, 4:15. That's not possible. We also have to recap.
Yes, that is true.
So it serves no purpose.
Any date next week then, Lordship.
List again in the next week for admission. Sorry, Mr. Sharma, I was taking note, but what to do?
Yes, I understand, Lordship.
I was getting ready to dictate the judgment. I don't know which way it will go, but
Yeah, that is always there.
I've written more than one.
I understand, Lordship. I was seeing, putting everything.
What to do? It's
So therefore, I was insisting if it had been disposed.
what happens is with this discrepancy, there is if the judge commits a mistake, then it creates
Yes,
a
yes,
trouble for
yes,
both
yes.
sides. That's not the correct approach. So the fact he is referring to documents which I am not getting. His 103 is my 132.
Yes, yes. In the judgment, if there is wrongly something is recorded, it becomes a public document later on.
That's the
Definitely.
problem. What to
Yes,
do?
Lordship. I understand that.
Anyway, bad luck for today.
It's okay.
So sorry for the inconvenience, my lord.
Huh?
Just
Sorry
a date.
So what to do? We have just lost out on 1 hour.
Next week, any date, if your Lordship will just indicate a date.
What date do you want?
Any hearing date, Lordship.
Next Thursday? Good.
Next Thursday. Oblige, Your Lordship.
See, this is also very unfair. Every case people are asking for date. Now I can fix a date when I am handling. I don't know who will be the learned judge handling this bench. And everybody wants a date. Now it could be a list with 70 matters for all you know. And then out of 70, 55 to 60 is adjourned. The bar asks for a date but never acts responsibly when the learned judge comes reading the brief. And then there is an adjournment. My senior is out of station. My so-and-so is not well. So-and-so is not well. And then the judge who comes reading the brief, he simply wastes his time. This is what is going on. Everybody wants a fixed date, but nobody has a commitment to do it on that day. One party will do it, the other party will ask for time. This is what is going on. What to do? You take a date on 10th of December. 10th of December. 10th of December. Please rectify the pagination.
Lordship, we are doing right now.
May please your lordship. In this case, lordship, yesterday, lordship, I have received a copy of the affidavit filed by the respondent number 3, lordship, government. So I want to file reply, lordship, 2 weeks time, lordship.
Lordship. Ms. P. Bhattacharya, learned counsel for the petitioner submits that a copy of the counter affidavit filed by the respondent number 3 has been served upon her only yesterday. Stop. Therefore, 2 weeks time, 2 or 3.
2 weeks, lordship.
2 weeks time be granted to obtain instruction and file rejoinder if so required. The prayer is not opposed by learned counsel appearing for the respondents. Appearance Ms. M. Bhattacharya for additional.
1 to 4 I am appearing, lordship. 1 to 4 I am
1 to
appearing.
4 and Mr. SP Das
For respond number 6, 7, and 8, my lord.
for number 6, 7. And who is for 5?
Finance.
Mr. H. Cholia for respond number. No objection.
Only one pair, lordship. Petitioner is going to return in the month of December 31st. So before that, one date may be fixed, lordship.
30th of December.
December, lordship. 31st of December.
You want time and you want a date to be
Because
fixed.
I received yesterday, lordship, copy. So I want to file it. Any date before vacation, lordship.
12th of December.
Apply this.
May it please your lordship. Lordship, this matter pertains to selection and appointment, my lord, to the post of junior assistant, my lord, in the fire services of the Airports Authority of India, my lord, in my lord, Guwahati, my lord. Here, my lord, the Airport Authority, it pertains to, my lord, he was not selected because of the fact that he had less eyesight, my lord, as per their this thing, my lord, and height was not as per the, my lord, advertisement. Lordship can come to, my lord, the advertisement, my lord, which is at page 19, my lord. That is the advertisement. It was for junior assistant, Airports Authority of India. So now, my lord, just in a nutshell, I want to say, my lord, that the issue was that in the last occasion, your lordship, it was placed before your lordship that there is a difference of opinion between what their medical board has given, and we had subsequently approached the tier 1 hospital of my lord, tier 1 hospital, wherein our eyesight and height was as per the advertisement required. There is a difference of opinion between two. So my humble prayer was that on the last occasion I had said that, my lord, if an independent inquiry can be done, so then, my lord, a neutral party with that will be satisfied. That is the issue, my lord. So otherwise, that is the current issue.
And in that, my lord, they have also filed the affidavit, bringing on record on the last occasion, my lord, their report, as well as I have annexed in the writ petition my report. That from a tier 1 hospital, government reputed hospital, that my eyesight is, my lord, as per the advertisement, and my height is 164.5 as per my medical, my lord, where I have taken the medical record. And the requirement is actually 167 in the advertisement. But if you are from a hill state, then my lord, you get a 3 centimeter relaxation. And that 3 centimeter relaxation, it becomes 164.
So what is the height requirement as per the advertisement?
163 for him.
From
belonging to
yes,
Hill State Lordship.
163 cm.
Yes,
Yeah.
Lordship.
And what is his actual?
The height has been found by the medical board was Lordship. Lordship may come to page 73.
Lordship will come to page 23 first, my lord. 23 is the relaxation, my lord. Lordship will come to page 23 of my
No,
report.
that's fine. He's saying 163 for you.
That's fine.
So what is your height?
Height, my lord, I will come to page
Oh, what is the height?
164.5. My height is 164.5.
The height that is required for him, Lordship, is 164.
I am 0.5.
Being, since he belongs to Hill State Lordship. And the height that was recorded by the medical board was 163 centimeters, Lordship. That was recorded when the medical board conducted the examination upon him, Lordship. So what has happened here, Lordship? Once he was disqualified, Lordship, thereafter he filed a representation before the AI, Lordship, that he do not have bow legs. He come up with a different reason that he do not have bow legs. That's why
he doesn't have what?
Bow legs, Lordship.
Bow legs.
Bow legs, Lordship. Yes, Lordship. So we replied to him on 26/9 that you were disqualified because you did not meet the requisite height and eyesight, Lordship.
Where is that letter?
Lordship, that letter, your Lordship will find at page 50. Of
50.
the repetition, 50, Lordship.
That is a letter, my lord, to my reply. That is a reply to my representation.
His representation, your Lordship, dated 11/9/2024, that your Lordship will find at page 49. No? Lordship, at page 48 is his representation, Lordship. And at page 50 is our reply, Lordship.
So this was done in Agartala.
It was
Agartala, Lordship, yes. Under the Director of Health Services, Agartala, Lordship.
Why Agartala?
They wanted a neutral ground, maybe, Lordship, because most of the this was specifically for candidates belonging to the northeastern states, Lordship. And there were also candidates from Manipur, so they chose Agartala, Lord.
My lord, after this particular checkup which they did, they gave us a reply in September 26, my lord, which is at page 50, saying that our eyesight and our height is not as per the advertisement. Thereafter, my lord, we immediately went to the reputed medical hospital, Jawaharlal Nehru Institute of Medical Science. There, my lord, we had a checkup regarding eyesight. If your lordship comes to page 51, page 51, my lord, there, my lord, we'll see my advice is VN 6/6, 6/6, refractive B accepts plano 6/6, but near VN normal, color VN normal, night blindness absent, and patient is visually fit. Then, my lord, the next is, my lord, for height. Next is for height. Height is outpatient record, Longjam Vidyasagar, my lord, department medicine. My lord, health checkup, height is 164.5 centimeters. That is my height has been recorded. And now Lordship will come to the main advert. I just want to show the advertisement, my lord. The advert at page 23. Directly, my lord, will come to page 23.
Yes.
Of the writ petition. Page 23, my lord, physical fitness, if your lordship sees, there's a block called physical fitness. There, physical fitness, has your lordship got?
Yes.
Below, my lord, will see height. Height is not less than 167 centimeters. That is for male, that's for general. My lord, and lordship will come to the bottom below, my lord, there are two hashes there. Relaxation of 3 centimeters in height for both male and female candidates, and chest measurements and proportionate relaxation in weight will be allowed for heel area candidates, my lord. So see 3 centimeter, my lord. If you minus 167 minus 3, my lord, it is 164. So I am 0.5 above the required rate. And my lord will come to now, my lord will come to the bona fide certificate, my lord, which we have to show the department, my lord. That I have annexed, my lord, at page 55, annexure 10. That is the bona fide certificate which goes to show I am from
And
the.
what is the vision requirement?
Oh, yes,
6
sir.
by 6.
Vision also 6 by
6 by
6, my lord.
6.
6 by 6, my lord.
Without glass.
Without glass, my lord. And that my lord here, my lord. I distance vision 6 by 6 with each eye without glasses, my lord.
And
near
what is the vision and height found by the doctor's figures?
Doctors found, lordship, that is at the.
Where is it stated in the affidavit?
Lordship, we have stated here, lordship. Para 4, page 67, lordship, of the affidavit in opposition, lordship, we have filed.
Para 4.
Para 4. May I read, lordship?
Just a minute. Page 67.
Page 66, lordship, para 4.
Yes.
That with regard to the statements made in paragraph 5 and 6 of the writ petition, the deponent humbly begs to state that the same is false, misleading, and concocted, and hence the same is denied. The statements made by the petitioner stating that he was disqualified on the ground of bow legs is absolutely false. The rule of recruitment is those no. Lordship, just below that, further it be pertinent to mention herein that the petitioner was declared unfit by a team of expert doctors of Government Medical Hospital Agartala on the ground of defective vision and lesser height. Visually, right 6 by 12, left 6 by 18, and height 163 centimeters against both eye and 164 centimeters respectively. Moreover, the required height as mentioned in the advertisement was 167 centimeters, and the advertisement provided for 3 centimeters relaxation for candidates belonging to heels area, that is 164 centimeters. Even in that case, the petitioner's height was found to be 163 centimeters. The decision of the medical board for medical examination is final, and there is no provision of appeal, and hence there is no scope for constitution of a fresh medical board. The reports are annexed in Annexure 1, lordship, that your lordship will find at page 73. His height that was mentioned, lordship, page 73 of the affidavit in opposition, lordship. Height calculated as 163 centimeters. And in fact, his first contention about his bow legs, lordship will find just below that disqualifications, bow legs nil. So we have never mentioned him that he was disqualified on the ground of bow legs.
So only grounds are that
yes, lordship.
Height and vision.
Yes, lordship.
So he has also produced some document from central government.
Whether those doctors are aware that he appeared for a recruitment process and that he was disqualified.
Simple answer is we'll subject him to another test in Guwahati
Yes,
Medical
yes.
College, and then
And
whatever
my lord,
be the
for that I have a
report.
judgment also.
But
if I
lordship,
want, like,
one
to
thing
place-
I want to just submit, lordship, there were 85 candidates who were disqualified, lordship. If we allow remedical for him, subject your
No, you will
lordship,
not allow. The court will allow.
court will allow, lordship.
You will not allow.
Yes, lordship.
You have rejected it. Court will allow. So what do you have to
Lordship,
say?
other 85, 84 will come, lordship,
That
because
means
they,
if they come, have they told you that they'll come?
but there is no instance of malafides in the decision of the medical
No,
board,
it's
lordship.
bona fide. But there can be mistakes. If he had not produced some material to show that your findings are prima facie wrong, then the matter would have been different. He has produced these documents now. Where is that?
My lord, page
Lordship,
50,
first he come-
50, my lord, 51, from 51 to 54, my lord. 51 and 52 are type copies, my lord. First one is the, my lord, eyesight,
Jawaharlal Nehru Institute of Medical Science.
Parampot.
Where is this Parampot?
My lord, it's in Manipur, my lord. It's a tier 1 hospital of the, my lord, it's a government hospital.
So any health department standing council here? Assam Health Department? Mr. Barua, can you just request someone to come? Where is your client now? Where does he stay?
Lordship, he is actually Manipur. He's from Manipur. He's from Manipur. He's in Manipur, my lord. So I can ask him to come down, my lord. If your lordship, he's ready for my lord go and having a testing also.
We'll ask the superintendent of GMCH to record this to his height and eyesight
Yes, sir.
and submit a report in seal cover.
My lord.
And then on the next day, we'll open it and
Lordship.
it's a simple exercise. If this report, whatever the report is, we'll not even mention what is there. Just to record his height and his eyesight, vision, and submit a report in seal cover. That's all. Depending on the outcome, we'll pass an order in the writ petition.
Gotcha.
We take down. Heard Mr. A. Fukan, counsel appearing for the writ petitioner. Also heard Mr. D. Decker, Learned Standing Counsel, Airport Authority of India, appearing for the respondents. Full stop. On
Advertisement is 30/12/2023.
what is the date of the advertisement?
30/12/2023.
On 30/12/2023, the respondent, Standing Council, Airport Authority, you write Learned Standing Council, Learned Council appearing for all the respondents. Stuff. On so and so, the respondent number
There is only one respondent, Lordship, Airport Authority of India.
appearing for the
RED.
respondent. The respondent in this case had issued an advertisement notice on 30/12/2023, inviting applications for filling up various posts, including the post of junior assistant, bracket fire service. In response to the said application, the petitioner had submitted his candidature. After completion of the selection process, the candidature of the petitioner was rejected on the twin grounds that he did not meet the minimum height requirement as per the advertisement notice, and also that his eyesight did not measure up to the minimum standards. Full stop. By referring to the requirements under the advertisement notice, Mr. Fukan has made an attempt to convince this court by contending that a central government institution, namely
Jawaharlal Nehru Institute of Medical Science,
Jawaharlal Nehru Institution of Medical Science, has verified the petitioner's physical features and submitted a report according to which he does meet the requirement laid down in the advertisement notice. Therefore, the decision to reject the candidature of the petitioner is wholly arbitrary. Full stop. Mr. Decker, on the other hand, submits that a team of doctors constituting a medical board had examined the petitioners and have found to be lacking in the medical standards of height and eyesight. Therefore, there is no illegality in the decision of the authorities to reject the candidature of the petitioner. Full stop. Whether the petitioner meets the eyesight and height requirement are matters to be verified by the medical practitioners. Full stop. Ordinarily, this court would accept the stand of the recruiting agency if the same is supported by relevant materials. However, in the present case, the petitioner has produced contradictory medical documents issued by competent hospital which supports his contention. Therefore, this court is of the opinion that the petitioner has made out a prima facie case for re-verification of his physical features pertaining to height and eyesight. Full stop. Having regard to the facts and circumstances of the case, as well as the urgency involved in this matter. This court is of the opinion that the superintendent of Guwahati Medical College Hospital at Guwahati be asked to carry out the measurement of height and eyesight of the petitioner and thereafter submit a report to this court in seal cover to be routed through the Learned Standing Council, Health Department, Assam, 3A Cholia, Custom. Ordered accordingly, the petitioner to appear before the superintendent of GMCH.
My lord, after a week, I'll ask him to come right away. 3 days, my lord, 3 days time may be given, he'll come. Because there was a problem going on in Manipur also. My lord, he'll come. Out of state.
Within a week from today. And produce a certified copy of this order. Stop. The date of appearance of the petitioner can be coordinated by the petitioner's counsel through Mr. A. Chalia, Learned SC Standing Council, Learned Standing Council, Health Department, Assam. A copy of this order be also furnished to Mr. A. Chalia for doing the readful. After recording the measurements, the report be placed in a seal cover. List this case again on 18th December 2024.
Lordship, the interim may be extended till that date.
Interim order part passed earlier to continue till then.
Deeply obliged. Deeply obliged.
Yeah, my lord. But it got to appoint 5 persons. And 2 persons have already been appointed, my lord. Remaining 3 persons are left to be appointed, my lord. Process is on to appoint the petitioners, my lord. Lordship will post in the first week of January. Most within 3 weeks, they will be appointed, my lord.
Yes,
Process. Lordship will post it in the first week of January.
As Bishop and Counsel for the petitioner. Also heard Mr. S. Bora who submits that out of the 5 candidates, 2 have already been appointed and the process is underway to issue appointment orders to the remaining 3. Therefore, Mr. Bora seeks posting of this matter again in the first week of January so as to enable the authorities to complete the process. Such request made by Mr. Bora is not opposed by the counsel for the petitioner. In view of the above, let this matter be listed again in the first week of January 2025.
This is the case, my lord, where 583 persons are to be given the area salary.
Instruction slip, photo slip,
and out of that, this requires an amount of 27 crore rupees, my lord. And the GMC have received 13.50 crore rupees, and now it has been distributed. That amount has been distributed to the all the persons which are the area had to be given, my lord. That has only been distributed, and the remaining amount, when it comes from the government, my lord, it will be done full amount. Full amount is 27 crores is required.
With your lordship permission. Well, we are not concerned with others who are slipping over their rights. One petitioner is before your lordship. To him, my lord, 29 lakhs 41,000 was due. Out of that, 13 lakhs has been paid and 16 lakhs is due. So, my lord, my friend should not be bothered at this time for all because the others have not come on contempt. This is the only petitioner he could have carved out and cleared this to avoid the contempt of this court. This plea has been taken on a number of occasions.
The amount, 50% amount has been given to the GMC. And there are 583 persons are there. All has been distributed by that amount.
No, I understand, but are you not modifying the court order?
But there are other persons.
The court says pay him, you said that no, we'll pay, but we'll pay everyone equally. So
but there are
whatever
other persons also petition then filed to pay the all the 43%. There are other persons also.
No, what you have to say, contempt petition only yes fine.
Well, that one person is there, my lord. But at the same time, my lord, that amount had to be distributed, my lord. The person, entire amount you have not received it, my lord. That's the difficulty, my lord. Ultimately, you have to get all the 583 persons, all their amount to be due.
And it will amount to contempt the court.
My lord, contempt.
I will get the instruction, my lord, what the amount, what the amount left, my lord. if there are any amount
What
left.
you do with the amount, how you pay others, that's another matter. But you have the money, but you're not paying him.
Now the money has been given, my lord,
Where
money
is the
part has
order?
been
Where is the
distributed.
direction?
My lord, the order is at page number 9 there. And
number?
effective, if page number 9, but the operative portion of the order is at page 117. And my lord, only
Acha, how many petitioners were there?
only one contender in the original.
But in the petition, how many
Originally
583.
583. And the order of this court is of 1/11/2022. 1 year is the limitation time for the contempt. The others have not come. Only
No,
this person.
That's another matter, but the order of the court is equally applicable to everyone.
That is, but they have.
They
but
can't
they
just pick and choose. I thought it was a single writ petition filed by a single
No,
individual.
but the others have not come on contempt. Only this person has come on contempt.
Maybe, but the order of the court, the
But
authorities. will-
first, my lord, they should have purged this contempt by at least clearing this petitioner who has come and agitated his rights.
No, they are saying that the fund is not available. Otherwise, that's
My
why
lord-
we can't pay the entire amount.
My lord, this whole plea was taken during the entire writ petition, and it was at that time the court gave the order after hearing all that it should be paid within a period of time period that has long expired.
Fine, but you have to show that despite having the fund, they are not paying. Willful disobedience is only a contempt. If they do not have the fund, there is no question of contempt. You have to implicate the person who is responsible for releasing the fund. You have to do it only, you can do it only when he was a party and there was a direction issued to him to release the fund. Otherwise, how can the courts will pass orders? They are pleased that we don't have the money. Whatever money we got, we distributed it amongst these 500 and so and so. Once we get the money, we'll pay it.
They have the
How can
government-
there be a contempt on that?
My lord, the government has money for all freebies, but not to pay
No,
this
that
pension.
is a political statement, Mr. Kaur. We can't get into that.
Now is
That right place is in the assembly.
My lord,
You go there and
these
raise it.
words have fallen from this court only. I'm only picking up the words that has fallen from this court.
This court means?
Means from the High Court.
That is another matter. We are concerned with the contempt case.
Yes,
Let us go legally. What is legally correct, we'll do it. We are not supposed to act as crusaders and campaigners, right?
Yes, yes, yes.
So once the order is passed by the court, it is not appealed.
Yes.
And there is no valid reason not to comply with.
Yes.
Then it will be treated as a willful disobedience.
Yes.
That you agree?
Yes, yes.
They are saying, we need this much money, we have got this much, we have paid proportionately. The moment we get the balance, we'll pay the rest. Is it a case of willful disobedience of
My
the
lord,
court?
your lordship will see their explanation from the day when the order was passed. The order was passed in page number 117. Your lordship may kindly look into the last paragraph. It's not that this is an ex parte order, my lord.
Thereafter, the process has been started, my lord. The amount has been, the amount we receive, we have distributed it.
They have to satisfy from the chronology of events after 1/11/2022 how they have processed this order of this court. My lord. That's not there. On the
So
record.
is there a statement that despite having the money, they are sitting over it and not paying? Is there any
No, my lord,
statement? in the
no, my lord.
contempt case?
That statement, I am going only by the order. I can only say that this order of the court has not been complied with. Now it's between your lordship and the contemptor how this order is complied with. I
That's
can only
right.
put
He's
that.
saying we don't
I
have
can
the
only
money.
ignite the machine, but I cannot come between the court and the contemptor. Your lordship knows my petition.
Then you wait because we can't help it. Then
No,
we-
your lord, but they have not given the chronology of the events, how they had processed this from the order when it was passed by this court until date. Simply making an oral statement that we have the fund, we don't have the fund. Let them bring it on record by an affidavit giving the chronology of events, how they had processed this
Affidavit
order
has
of the
been-
course.
Affidavit had been filed, my lord, already. Thereafter, my lord, there he had impleaded, showing that the finance department had been impleaded. One person from the secretary has
How
been
long
impleaded. Thereafter, the
person who
fund has come. Fund has come and we have distributed it.
affidavit has been filed.
Affidavit filed.
Have you, Mr. Kaur, have you received the
Yes, my
affidavit?
lord, I have retired on my lord, say 31/8/2006.
Oh, I have understood. Please don't, you are a senior
After the
counsel.
affidavit,
You
new
can't
person
say
has
that
been-
I have retired, I want my money, I don't know anything.
The
That kind
pension
of
is
argument
not a
you can't.
bounty which they are giving, my lord.
You argue the matter.
No, no, my lord, why should I argue, my lord? Because, my
I
lord,
am asking you a simple question.
yes, my lord.
If they have, despite having the money, if they are sitting over the matter, a deliberate disregard to the court's order, it will be a case of contempt. They are coming and saying that there are 508 employees. To give them the arrear pay, we'll need this much of money, which we are awaiting from the government. The government has given us this many crores. We have proportionally distributed it. Your client has also got some. Moment the balance amount comes, we will pay them. Is it a case of contempt of court?
No, my submission will be a little bit different, as I have already told them. My lord, order of the court has been passed. Now, they have to comply with that order.
Where is the direction to the finance department to release the money?
They subsequently in this contempt petition, the court asks us to implement the finance department as a party.
Sorry, this will
we
not
have
work here.
We have done it.
Now, but is there a specific direction to the finance department that this is the amount you release it within 3 months?
No, my lord, we have made the subsequently the finance department was with, they came with a plea that the finance department was in the hurdle in complying with the order of the
Mr.
court.
Kaur, I am asking in the main judgment order.
The main judgment not there.
It is a one-page order.
No.
One and
This
a
is
half
a
page
consent
order.
order.
Sorry?
This is a consent order.
Where is the consent? Let us see.
Page 117.
Who has given the consent for what?
17.
Yes. What is the consent, please?
In view of the consent of the parties, my lord.
No, where is the consent?
So in view of the page 117 last paragraph, my lord, in view of the consent of the parties. My lord, let them say, my lord, this arguing will not take us anywhere. Let them say that when they are contemplating to pay, it cannot be on infinity, my lord.
Come to that.
Yes.
Come to that.
It can't be on infinity. A person today, he came at his now 75, 79 years. He's asking me that, Mr. Kwon, when I'm getting my pension, I am the money that I have got all these years, the liabilities that were there, I had cleared it. I have no money today. So at least I should go and tell him that, yes.
See, Mr. Kaur, what I am trying to point out, which I did not want to say.
Yes, madam.
I have been saying this again and again. In these matters where chunk of money is required, it is the finance department which will have to give the money. Na?
Yes, ma'am.
You can get rosy, flowery orders, but if the money doesn't come, this is how you are stuck. Therefore, even as senior counsels and even as judges, I think we should figure out what is the money and either get a commitment from the finance department or issue a direction.
Well, that's why your lordship.
Otherwise, the finance department.
No, that's why on the earlier occasion, because they were taking a plea that the finance department was a hurdle in the releasing the funds and all. That's why we have implemented them as a party, and after that, this money has come.
So who is appearing for the finance department?
What finance department is?
Finance department.
Jayanta Nalika. Is the
No,
commission
who is the council? Who is the council for the finance department?
No, service is complete or not? Because nobody has filed their affidavit.
Has notice been issued to the finance department commissioner?
I was filed at 37713.
So no notice has been issued to the respondent numbers 2 and 3.
No, I'm just checking, my lord. You are checking it online. We filed it on 8/12/2023. And this pension was paid to me from September 2006 to December 2012 for 112 months. Then when the
All right. The answers the court is asking the questions that these are never going to come. There was no notice ever issued to this. Yes.
We're just checking, my lord.
Yes. Heard Mr. B.D. Cole and senior counsel appearing for the petitioner. Also heard Mr. S. Boral and a counsel representing the respondent number 1, who submits that on receipt of
13.5
money from the government. Part payment of area pensions have been made to all the 583
83
retired employees of the corporation. However, as soon as the balance amount of money is received from the government, the remaining dues will also be cleared in compliance of the court's order dated 1/11/2022. Full stop. It appears from the record that from the submission of Mr. Bora, it is clear that due to non-availability of funds, the entire amount of area dues could not be paid to the petitioner and the similarly situated other persons. Full stop. The Commissioner and Secretary of the Finance Department, as well as the Housing and Urban Affairs Department, have both been implicated as respondent numbers 2 and 3 by order dated 19/2/2024, passed by this court in IA bracket C bracket close number 3713 of 2023. However, I find that notice is yet to be issued to the newly implicated respondent numbers 2 and 3. In view of the above, issue notice on respondent numbers 2 and 3 returnable in Mr. Kaur. Mr. Kaur,
Yes, ma'am.
will issue notice today? Respondent.
Your lordship, I think your lordship will kindly check the order, madam, 22/2024. If we have also less track, madam, because some of the orders 22
22?
to 2024.
In the contempt case, there is no
in
such order. Let
contempt.
us see the IA.
Contempt.
And the contempt case order is 19/2024. Let's see the IA.
The 19, after that, 22 order is not there, madam.
No, there is no order of 22 here. Returnable in 3 weeks.
In the online, it is showing that the steps were taken on 22/2/2024 on this two respondent, postal Talabana.
So that could be on the IA.
No, your 19 order, because we had taken steps on 22/2.
Taken according.
On
Please ask your junior to have a look at this. Because unless notice is sent to them,
No, we'll check. Because we have.
maybe there is some discrepancy somewhere.
Because our record shows that we had taken Talabana on 22/2/2020.
Maybe something is missing. Just have a look at it. Meanwhile, we'll move on with the
Yes,
other
yes,
matters.
Your Lordship, for item 12 and 13, my senior is having some personal difficulties. So if you may please fix the matter, Your Lordship.
That has been the fate of this matter, my lord, for the last 3-4 occasions.
Who is your senior?
M.K. Chaudhary, Your Honor.
Maybe just.
He's having some personal difficulties, Your Lordship. If you may fix the matter any date, Your Lordship, apart from 6, 12, and 16 December, Your Lordship.
You agree on a date?
Yes.
Prior concern was taken, Your Lordship.
Can it be on 10th? 10th. Below 10th. 10th of.
When these review petitions were called up before this court today. And submission has been made that the learned senior counsel, Mr. M.K. Chaudhary.
Yes, Your Honor.
Praying for him.
Is unable to come to court today due to some personal reasons, and therefore these matters be listed again on 10th of December 2024. The prayer is not opposed by the learned counsel appearing for the other parties. In view of the above, these matters stands adjourned, raised to release the cases.
I oblige, Your Honor.
May it please your lordship. Lordship, as per Lawajima report, service has not been completed, lordship. Correct for service report.
Your name, please?
A.K. Kanu. A.K. Kanu.
Mr. A.K. Kanu, learned counsel is present for the petitioner. Ms. M. Bhattacharya, learned additional senior government advocate Assam, has appeared for the state. From the Lojima Court order dated 26/11/2024, it appears that this matter is not ready as regards service. As such, await service report on service report on whom? Which respondent?
Respondent number 8, Your Lord.
On respondent number 8, list the matter accordingly.
Oblige.
Hearing.
Back to your lord. My lord, in this matter, we are alleging, my lord, bias against the selected candidate as they are one of the selected candidates father participated in the selection process. However, this honorable court on the last occasion directed me to obtain instruction. It is a fact that the petitioner, my lord, in the meantime, he has got a job in government of Assam in the forest department, my lord. He is working.
We will keep the issues open to be decided, legal issues.
Well, that he has already been, lordships appointed in 2017. Now he is presently working in the, my lord, this is the transfer order, my lord. He is presently working in the, my lord, Northern Division, my lord. A forest range officer, my lord.
Is working as?
Forest range officer, my lord. Range officer, ranger, my lord. Is ranger, my lord, forest range officer.
And what is the post here?
My lord,
Assistant Revenue Officer.
Assistant Revenue Officer.
Ranger is more
And the pay
lucrative.
scale is, my lord, 8,000 and 22,000.
This is
Now he is
22.
22,000.
So what? Huh?
I'll leave it to this honorable court, my lord.
No, there is nothing to leave. If you want to pursue, but if you succeed, you will have to give up your job and come and join here. We will not entertain an academic exercise.
Lordship will keep the issues open and
Because what is the point? This is not a PIL.
did not appear.
And then we'll close it.
Close it.
Then take down. So you argue another matter, another day. Mr. J. Patwari, learned counsel for the writ petitioner, also heard Mr. G. Chutia, learned standing counsel KSC, appearing for the respondent numbers 2 to 6. Mr. A. Kalita, learned counsel, is present on behalf of the respondent numbers 8, 9, and 10. Whereas Mr. D. Bora, D. Das, learned counsel, has appeared for the respondent number 7. Who is for 1 and 12? 1 and 12? Mr. C.K.S. Borua, learned counsel, is present for respondent numbers 1 and 12. But the writ petitioner herein had participated in the recruitment process initiated by the
Karbi Anglong Autonomous Council.
authorities of Karbi Anglong Autonomous Council for filling up a few vacant posts of Assistant Revenue Officer. Wide advertisement notice dated 31/5/2014. Full stop. On completion of the selection process, the respondent numbers 8, 9, and 10 emerged as selected candidates, and consequently, appointment orders were also issued in their favor. Full stop. The 8, 9, and 10, is it?
Yes.
8, 9,
Yes.
and 10. Alleging that the selection process stood vitiated on account of biasness and malpractices committed in respect thereof, the instant writ petition has been filed, alleging that the member secretary of the selection board
Respondent number 7.
was the father of respondent number 7.
No. Respondent
Number 7,
the
that is the
father.
member secretary of the selection board, had influenced the entire selection process for having his son,
R10. Respondent number 10.
that is respondent number 10, included in the select list. That about, what is the allegation about 8 and 9?
My lord, there are anomalies in the answer scripts.
Insofar as the response numbers 8 and 9, it has been alleged that there were serious anomalies in their answer scripts for which the said respondents also could not have been selected. Full stop. The fact remains that after the publication of the select list way back in the year
2016, my lord. 2016.
16, the private respondents have joined their services and pursuant to their appointment, the private respondents have joined their services as ARO. Full stop. Not only that, during the pendency of the writ petition, the petitioner was appointed as forest ranger, and he is also presently serving as forest ranger under the Forest Department, Government of Assam, Dipu.
No, my lord.
Government,
State of
Forest-
Assam, my lord.
Government of Assam?
Government of Assam, my lord.
Government of Assam, drawing a pay scale of more than rupees 22,000 per month, which is substantially higher than the pay scale drawn by the assistant revenue officers. Full stop. In view of the above developments, this matter was adjourned so as to enable the petitioner's counsel to obtain instruction as to whether his client would still be willing to join as ARO in the event he succeeds in the writ petition. Full stop. Responding to the above, Mr. Patwari on instruction submits that since the petitioner is already suitably employed in a government job, drawing a higher pay scale, hence he would not be interested to join as ARO even if he succeeds in the writ petition. If that be so, entertaining the writ petition at this stage would be of mere academic importance. Full stop. Since the private respondents have already joined their respective jobs and are serving since past several years, this court is of the view that the present is not a fit case where the writ petition should be finally heard and decided merely for an academic purpose. As such, as agreed to by learned counsel for all the sides, this writ petition is being disposed of by providing that all legal issues raised in the writ petition shall remain open to be dealt with in an appropriate proceeding in future as and when the occasion arises. Is there any interim order?
No.
No, my lord. No, my lord. The PT, my lord, 8, 9, and 10, my lord, not 2016, 14, they joined, my lord. Appointment order is of 2014.
2014. They were appointed in 2004. Writ petition stands disposed of accordingly.
Lord, I have checked the record. My lord, the order of 19 asks us to take steps on the respondent number 2 and 3 newly implemented, and we are asked to amend the cost title. We have amended the cost title. We have taken steps on them, and my learned friend is appearing for the respondent number 3.
Notice has not been issued.
No, notices are issued. We have taken
Let's
steps.
see, where is the order of issue notice?
Notice, it seems notice has been issued, man. Respondent number 3, I have filed my okay. Only thing that respondent number 2, there is nothing to show that respondent number 2 had received the notice.
AD card is yet to return, and they say that for respondent number 2. And we are asked to file the amended cost title. Amended cost title has been incorporated, madam.
Where is the order issuing notice to the?
Well, that is not. My lord, your lordship will see the I. The last line of the I order. Once order, Diko.
No, after their implementation in the contempt case, no notice is required to be sent.
No, my lord, your lordship will look into the order of the in the I.
In the IA,
notice had to be sent, my lord, because I think notice had been issued because respondent number 3 has filed an affidavit. I have filed my for respondent number 3.
And what about 2?
2, there is nothing to show that a 2, there is some notice has gone to the 2.
No, notices we have taken.
But the ID card and everything, that
service report.
Service report
There is a
completing
difference.
the service.
So we'll keep it open and we'll be, but some, after 5 years, it will be seen that no notice was issued.
No, my lord, your lordship will say
Where
notices.
is the notice issued to respond
In
number
the
2?
order, I order my head. Your, that is tagged with the contempt petition, your lord.
Show us, where is the notice issued to respond number 2? After impleachment, notice has to go.
Just 1 second. Because when the order was dictated, in terms of that order, we have taken steps for respondent number 2 and 3 newly implemented. We are asked to amend the cost title. We have amended the cost title. My learned friend has filed a ukalatnama on behalf of respondent number 3. He has forgotten it, otherwise he would have apprised it. Now, after looking into the record, he says that yes, I am appearing for the respondent number 3. And the office note on the administrative. If your lordship looks into 19.2 order, it says the petitioner to take steps for service of notice.
Where is the order saying issue notice on respond number 2?
That too I can.
That is not there. That's what I am written.
But the last, that too I don't know, my lord.
You don't know, it's already. Record reveals that no notice has yet been issued to the respond number 2. As such, issue notice upon the Mr. Bora for 1 and 3.
1 and 3.
Huh? We are appearing for 3.
Lordship, 1 and 3.
Verification of the records goes to show that no notice has yet been issued to the respond number 2, who is holding the post of Commissioner and Secretary in the Finance Department.
But notices have already gone from our registry or from this court.
I can't comment. But it's wrong. If it has gone, it's wrong. That's all I know. I'm not going to justify anything which is wrong. Either you argue that no need to issue notice.
No, these are all technicalities, my lord. These are all technicalities, my lord. Your lordship will take notice again on the respondent number 2. Yes, I will take
You
it.
will say that no notice was issued.
Why should I say? These are all the handmaids of justice.
Steps per step. See, what happens is people don't ultimately, I'm not blaming anyone, but I'm not giving a clean sheet also. People don't take responsibility. Everybody wants an order for the client. Let the system go to docs. In a contempt matter, if the contemptor is tomorrow hauled up and he comes and says that you have not issued a notice to me, what was my responsibility? Nobody is going to come forward and give an answer. Nobody.
My lord,
I have seen a number of cases where
your lordship
forgets to issue notice.
Your lordship is absolutely correct. But I was making the submission on the first step that this contempt petition limitations and all those things is not my own. I was quoting it just from the orders of the early orders from the Supreme Court, where they have said that if a contempt or case order has been passed, it has not been complied with, and someone comes in a contempt petition, they has to comply with the order of the contempt, because the person who has slept with it. But it is up to the discretion of your lordships whether to.
Where is the court asked to issue a summon or notice to the contemptor? Where is it? That's the question I'm asking.
2, my lord.
Huh?
2.
That's why. Where is it?
Others, they have come, it's no problem.
But finance is the issue and he is the one to release the finance.
No, we are obliged to your lordship for pointing it to us, but I was making the submission is not from my own, because I know my limitation as a counsel for the petitioner. It's your lordship's job and there how the order is compliant. I can only ignite the machine. I cannot go beyond it. I know my limitations.
You have done it. Now, any other matter you have today?
No, not before your lordships.
So you can have a peaceful lunch.
The material
You are
instructions.
at least lucky on that.
The material instruction has to be justified. Today, when the client came in the morning, my lord, nowadays, without in the live streaming, we have to show that at least we have pointed it out to the court. We cannot go by always silence, maybe not the best discretion for a lawyers nowadays.
Live streaming has changed everybody's life.
Yes.
For the good or bad?
No, it's good. It's good, my lord. It's I think it should improve. But now from the day this court, my lord, yesterday I was comparing the live streaming of High Court and the Supreme Court. Our visuals are better than this Honorable Supreme Court, but still a lot of
Don't compare High Court and Supreme Court.
No, but your lordship has to look into the pictures and all. There are lots of hotspots in the videos and all. Your lordship will see all the fluorescent light.
Court is above us.
Yes. But in our court also, your lordship will see the screen, my lord. There are lots of hotspots on top of the council's heads and all. This has to be done, my lord. Your lordship is the committee of the, I'm told of this, all this thing. Your lordship will see how these hotspots on the ceilings can be eliminated. Your lordship may have to change the lighting system because there is a blue cast over all the judges' faces and the lawyers' faces and all. This can be just changed by changing the lighting, my lord,
Alright.
that your lordship may consider.
We'll look into this suggestion. All right, Mr. Kwan. Yes.
Wait, Bill. Joseph, here in this case, we have challenged the punishment imposed upon the petitioner
Hmm.
by the departmental authorities, my lord.
Hmm.
And basic ground we have taken was out of the same facts and circumstances, the criminal proceeding as well as the departmental proceeding was completed. Before completion of the departmental proceeding, the criminal proceeding was completed and he was acquitted.
Hmm.
And the charges in the departmental proceeding as well as charges in the criminal proceeding are same. And the vital witnesses in both the proceeding are also same. my lord. On that ground, we have challenged the punishment imposed upon the petitioner by the
That's not a ground at all. That's no ground. If that is your case, then I can dictate the order.
from others ground is also there.
What is the other ground?
My lord,
Criminal trial, the standard of proof is beyond reasonable doubt.
yes,
Departmental proceeding is preponderance of.
yes,
So if the charges have been held to be proved,
yes.
you have to to show us why the inquiry report is not to be. So have you challenged the inquiry report on that ground? That
No.
it is perverse?
Yes.
Huh?
On that ground, well, basically on that ground we have taken.
What ground? Let us see what is the ground. Where are the pleadings? The ground of challenge of inquiry report.
Under para 14,
Para?
14 minute.
Yes.
The petition acceptably submitted before completion of the department proceeding, the criminal trial has been completed.
No, that's not a ground. I'm rejecting that. That's not a ground. There's no ground. Do you have any other ground apart from that? Acquittal in criminal proceeding does not lead to acquittal.
But that's correct. But there is a
That is correct. That is your only case.
but there is a several judgment in
What is it? Show me the
with
judgment.
me, Malad.
Which case?
I can show, Malad.
Yes. Which judgment you are relying upon?
But first of all, Malad, the AIR 1999 SC 1416 M.
Yes.
Paul Anthony
Yes.
versus the Bharat Gold Mines
Mm.
Limited, Malad.
Yes. What did it say?
Malad, para 34.
Mm. Mm.
Para 34 months. There is yet another reason for discarding the whole of the case of the respondents. As pointed out earlier, the criminal case as also the departmental proceeding were based on identical set of facts, namely the raid conducted at the appellant's residence and recovery of the incriminating articles thereon. Therefrom, the findings recorded by the inquiry officer, a copy of which has been placed before us, indicate that the charges framed against the appellant were sought to be proved by police officer and the Pan's witnesses, who had raided the house of the appellant and had effected recovery. They were the only witnesses examined by the inquiry officer, and the inquiry officer, relying upon their statement, came to the conclusion that the charges were established against the appellant. The same witnesses were examined in the criminal case, but the court, on a consideration of the entire evidence, came to the conclusion that no charge was conducted nor was any recovery made from the resident of the appellant. The whole case of the prosecution was thrown out and the appellant was acquitted. In this situation, therefore, where the appellant is acquitted by the judicial pronouncement with the findings that the raid and recovery at the residence of the appellant were not proved, it would be unjust, unfair, and rather oppressive to allow the findings recorded by the expert departmental proceeding to stand. Since the facts and evidences in both the proceedings, namely the departmental proceeding and the criminal case, were the same without there being any iota of difference, the distinction which is usually drawn as between the departmental proceeding and the criminal case on the basis of approach and burden of proof would not be applicable to the instant case. And the second one,
So
my lord.
this is on facts. Paul Anthony's observations are on facts of that case.
Yes, but my lord, in GM tank, next judgment, my lord. In GM tank case, my lord, at para 20, GM tank 2.
There are 20.
Yes, yes. Para 20, 30, and 31 minutes. Para 20 minute last part. It is thus seen that this is the case of no evidence. There is no iota of evidence against the appellant to hold that the appellant is guilty of having illegally accumulated excess income by way of gratification. The respondent failed to prove the charges level against the appellant. It is not disputed that the appellant, being a public servant, used to submit his early property, returning relating to his movable and immovable property, and the appellant has also submitted his return in the year 1975 showing his entire movable and the immovable asset. No query whatsoever raised about the movable immovable of the appellant. In fact, the respondent did not produce any evidence in support of the so-and-so. Likewise, the criminal proceeding were initiated against the appellant for the alleged charges punishable under the provision of PCI on the same set of facts and evidence. It is submitted that the departmental proceeding and the criminal case are based on identical and similar set of facts and evidences. The appellant has been honorably acquitted by the competent court on the same set of facts, evidence, and witness, and therefore the dismissal order based on the same set of facts, evidence on the departmental side is liable to be set aside in the interest of justice. Then, para 30, the judgment relied on by the learned counsel appearing for the respondent are distinguishable on facts and law. In this case, the departmental proceeding and the criminal case are based on identical and similar set of facts. And the charges in the departmental case against the appellant and the charges before the criminal court are one and the same. It is true that the nature of charges in the departmental proceeding and in the criminal case is grave. The nature of the case launched against the appellant on the basis of the evidence and material collected against him during inquiry and investigation, and as reflected in the charge sheet, factors mentioned are one and the same. In other words, charges, evidence, witnesses, circumstances are one and the same. In the present case, criminal and departmental proceeding have already noticed or granted on the same set of facts, namely raid conducted at the appellant's residence, recovery of articles therefrom. The investigation officer, Mr. So-and-so, and other departmental witnesses were the only witness examined by the inquiry officer, who by relying upon their statement came to the conclusion that the charges were established against the appellant. The same witness were examined in the criminal case, and the criminal court on the examination came to the conclusion that the prosecution has not proved the guilt alleged against the appellant beyond any reasonable doubt and acquitted the appellant by its judicial pronouncement with the findings that the charges has not been proved. It is also to be noticed that the judicial pronouncement was made after a regular trial and hot contest. Under these circumstances, it would be unjust and unfair and rather oppressive to allow the findings recorded in the departmental proceeding to stand. In our opinion, such facts and evidence in the departmental as well as criminal proceeding were the same without there being any iota. Any iota of difference, the appellant should succeed. The distinction which is usually proved between the departmental and criminal proceeding on the basis of the approach and burden of proof would not be applicable in the instant case. though the findings recorded in the domestic inquiry was found to be valid by the court below when there was an honorable acquittal of the employee during the pendency of the proceeding challenging the dismissal, the same request to be taken of and the decision of the Paul Anthony case will apply. We therefore hold that the appeal filed by the appellant deserved to be allowed. And recently, my lord, in 2024 also, the another judgment, my lord, 2024 1 SCC 175, my lord.
Yes.
First para 13, my lord. However, if the charges in the departmental inquiry and the criminal court are identical or similar, and if the evidences, witnesses, circumstances one and the same, then the matter requires a different dimension. If the court in judicial review concludes that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence, and the prosecution miserably failed to prove the charge, the court in judicial review can grant the redress in the certain circumstances. The court will be entitled to exercise its discretion and grant relief if it concludes that allowing the findings of the disciplinary proceeding to stand will be unjust, unfair, oppressive. Each case will turn on its own facts. And next one, para 26. Para 26, we are satisfied that the findings of the appellate judge in the criminal case clearly indicate that the charges against the appellant was not judged, not proved. In fact, the charge even stood disproved by the very prosecution evidence as held by the court. A fact is said to be disproved when, after consideration of the matters before it, the court either believes that it does not exist or consider its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. A fact is said to be not proved when is neither proved nor disproved. We are additionally satisfied that in the teeth of the finding of the appellant judge, the disciplinary proceeding and the order passed thereon cannot be allowed to stand. The charges were not just similar but identical, and the evidence, witnesses, circumstances were all the same. This is a case where the in exercise of our discretion we quash the orders of the disciplinary authority and the appellate authority, and allowing them to stand will be unjust, unfair, and oppressive.
These are all facts of the case.
Here in this case, my lord, the charge in the departmental proceeding is the ditto of the FIR. Ditto of the FIR in the allegation of charges.
What is the, let us see the FIR.
Yes, my lord. Well, the FIR is at page 24.
Page 24.
4 and relevant, but it is at page 26.
You have filed affidavit. You have filed affidavit. Yes.
With due respect, I have the honor to report you that I am homeguard in your DEF and posted in the accounts branch at your office. Sir Inspector so-and-so, currently posted in CIT Ulubari, Guwahati, has been trying to make physical relationship with me since the time he was posted as reserve officer in Chirang DF. On the night of so-and-so, he came to my house with his family. He again came to my house at around so-and-so alone and tried to kiss me forcefully, to which I objected. He asked me to go on bed with him, and at this I ran away from my room. As I am 6 months pregnant and knowing fully this fact, he said, and I looked very pretty even in my pregnancy, and asked me to shut the door. I therefore request you to take necessary action against him, and does oblige. And which was written to the Superintendent of Police, and Superintendent of Police was forwarded the same to the Dhaligaon PS, and subsequently the case has been registered. My lord.
Is registered under which section?
Well, registered under section 354. Next one, receive and registered by Dhaligaon PS case number under section 354, 354A, 354B, 511 IPC. And subsequently, charge sheet has been filed. Charge sheet is at page 27, my lord. The relevant is at page 28. Charge sheet has been filed under section 354, 354A, and 354B and 511.
Now come to the departmental
Yes,
proceeding. Where is the show
the
cause
show
notice?
cause notice is at page 34.
Page 34.
34. And the statement of allegation is at page 35. Page 35 with the statement of allegations. my lord. The allegation of charges will detail of the FIR. And the judgment of the trial court my lord, is at page 60.
So it is not your case that in the departmental proceeding, the charge could not be established. That's not your case.
That ground also have been taken, my lord. For basic ground, I have taken this that since in the criminal proceeding out of the same set of facts and evidences, the trial court has acquitted the petitioner. Even the presence of the petitioner could not be established by the prosecution. So in that case, the departmental proceeding which has been initiated against the petitioner, subsequently he was imposed punishment of dropping of one increment cannot be sustained. Even while in the trial court, they could not establish his presence on the day of occurrence in the place. It's clearly written in the judgment.
All right. Then what happened? Where is the reply of the petitioner? Show cause reply?
Well, show cause reply is at page 70. 37. Page 37. He totally denied the allegations.
Now, where is the enquiry report? Let us see
My
the findings.
enquiry report is at page 44.
Hmm.
Fact reveal at page 49. And where is the order of penalty? My order of penalty is at page 91 minute. It is appellate authorities order, my lord. The impugned order is page 80. Page 80. Page 80.
So this lady complainant, she was staying in a private residence or a government quarter?
In a government was shared with another lady constable. Lord.
And the judgment.
Judgment, my lord, is at page 60.
Page?
60. And the relevant portion, my lord, the final observation is at page 74, my lord. Page 74. Now, having considered the discussion above without going into the details of the ingredients of the LS offense, there is a clear doubt seen in the prosecution could not even establish regarding the presence of the accused person at the place of occurrence itself without any iota of doubt. Further, there is a doubt emerged out regarding the veracity of the evidence of the victim, who invariably had supported both the allegations against the accused person. But as it is already been discussed, there are loopholes and lacunae in the story of the prosecution, and prosecution could not prove the case beyond reasonable doubt. It creates serious doubt regarding the story of the prosecution, and in the criminal law, the doubt always give benefit to the accused person. Considering the situation for the discussion, it is clearly visible that prosecution totally failed to prove the LS offense against the accused person beyond reasonable doubt. Hence, the accused person so and so of all charges set liberty forthwith. And even when
So witnesses are same in the departmental as well
the
as.
vital witnesses are same. Because here is the two informant and another the woman police officer and the IO. These three are also examined in the departmental proceeding. But in departmental proceeding, two others, they are just communicated something. There's no vital, that is from the inquiry report, is just clearly vital. They have no role at all. This is the list of witnesses in both the proceeding. One, two, three. He is the SP. He just said that he has recommended the complaint to the OC. And then another is SPCID, who was arrested from here. That's why he reported. And Zitar Burman Dhaliga OC, he just said that I have received the complaint and subsequently registered a case and directed to investigate the matter.
Yes. That's all.
So, well, from these maladies is very clear that even the presence of the petitioner could not be established at the place of occurrence. In that case, the departmental proceeding cannot be sustained. And even the prior to imposing the punishment, the judgment of the learned trial court has already been communicated to the departmental authorities.
Yes.
Your lordship may kindly peruse the charges, lordship. Out of other charges, another charge was that grave misconduct, lordship. Being in a employee of a discipline force, lordship, this is also there because he entered into the premises of and this is admitted fact that he went there, lordship. And lordship, that apart, if your lordship may kindly peruse the inquiry report.
What is the misconduct here?
Lordship, misconduct, that means he entered, first day he went with his family. Next day, he again went to the premises alone. And due to, as the lady constable, she was also there in the house alone, lordship. And from the statement that she first offered him tea, then he asked for drinking water. When she went to the kitchen to take the drinking water, he subsequently went after her and he touched her. Then lordship,
So
she.
that's a private,
Private,
that's a criminal offense if at all. Where is the misconduct here? Misconduct has to be in discourse of discharge of official duty or in acting in violation of some rules, regulations while discharging official duty. These are private transactions. I'm not saying whether
Lordship.
this is right, wrong. I'm not on that. The
Lordship.
moral aspect, I'm not on that. But in somebody's house, some exchange happening between two persons, how does it become a misconduct under the?
Because 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 he is also from the same department and the victim, she also belongs to that department, lordship. So this has been, when reported, this action has been taken on the part of the discipline, that
All
means
right,
authority concerned.
I can grant you that. Let's grant you for the moment.
Lordship.
But where is the charge established in the departmental proceeding? What is the material to show that he had visited the house of that lady on that day? Where is the finding on that?
The statements, lordship.
No, where is the finding of the inquiry officer?
Yes, lordship, page 80.
Page?
80.
Page 80, the inquiry report is in page 44.
Inquiry report at page 44.
Yes.
Yes, lordship.
Where is the finding?
The witnesses were examined, lordship. Then the statement of, on page 47, statement
No, I've
of.
seen that. You show me the finding where the
Lordship,
inquiry officer
lordship.
says that because of these evidence.
Yes, lordship. Facts as revealed during the inquiry. Page 49, lordship. During inquiry of the DP drawn up against the inspector so-and-so, CID organization, as many as 6 witnesses were examined and their statements were recorded in writing. Moreover, documentary evidence such as copy of detailed report by memo number so-and-so, and copy of the FIR submitted by Anjali Karji, and all this, the following facts have been come out in the light after going through the statements of prosecution witnesses and the aforesaid documents as well as other relevant documents which are mentioned below. The delinquent inspector so-and-so was deputed to South Salmara on 8/5/2018 for investigation in connection with the CADPS case number so-and-so, along with Sri so-and-so, who was deputed to investigate the CIDPSK by providing a government vehicle. But Sri so-and-so, Assam had returned with the allotted vehicle, but the delinquent inspector Jamiul Ufra did not return to the CID headquarters along with him and came to Dhaligao directly without reporting the CID headquarters along with Sri so-and-so, which was admitted by him during recording his statement before me. The same was come also to the light during examination of prosecution witness Sri Pavindra Kumar Nas so-and-so, Assam, during the inquiry.
What I'm
So
asking
he was on official duty, lordship.
No, that's fine.
Yes,
You come to page 50.
lordship.
The second part of the clause 2.
Yes, lordship,
and
during the
3.
inquiry. It has been.
Where is the evidence to establish this?
Then the quarter of so-and-so, 13/5, while he was not present in her quarter, however, he along with his family met with.
13/5 is fine. He is himself admitted.
Yes, lordship, who remained
about
present in the
14/5?
same quarter. Again on the next day.
Yes, where is the evidence?
The delinquent so-and-so again visited her house, taking the opportunity of absence of Monu Mohilari Brahma, original occupier of the quarter. The delinquent took the opportunity of taking glass of water. He entered to her inside room without her permission and kissed her forcibly, taking opportunity of her aloneness, and also asked her to shut the door for the room, as well as molested her by using abusing words despite knowing that she was pregnant of 5 months.
Right. So these are findings of the inquiry officer, correct?
Lordship.
What is the basis of this finding?
This is the statement, lordship.
Statement of?
Statement of the victim.
Versus this statement of the
victim and that lady on whose quarter she is staying, lordship.
Which lady? Witness?
Monu Mohilari, witness number 4.
So that Monu Mohilari is present on 14/5/2018.
She was not present.
Then?
And this has been told by her, the victim. This is, she also stated in her statement.
That's correct. So
yes,
victim
lordship.
is the only one giving this.
Only one was there.
And the petitioner has denied this.
Lordship.
So on what basis can it be held that the charge has been proved? What is the legal parameter on this?
Lordship, the conclusion from the above facts and circumstances as revealed during the inquiry and considering of the statements of prosecution witnesses as well as relevant documents, it appears that the allegation regarding charges of serious misconduct on the part of the delinquent inspector is proved beyond reasonable doubt. But Lordship, that what Lordship was actually, because he was on duty. This is their Lordship.
No, Ms. Bhattacharya,
Yes,
please
Lordship.
try to understand the
Yes,
case.
Lordship.
We are on a legal journey in a
Lordship.
case, right? We are only concerned with the legal issues,
Lordship.
nothing else. So forget for a moment that he has been acquitted in the criminal case.
Lordship.
I am not even going into that. In order to impose a penalty,
Lordship.
there has to be a charge.
Lordship.
The charge has to be proved.
Lordship.
Then only the question of imposing penalty. Correct?
Lordship.
Now here the charge is that on 14/5/2018, he went to the house of the complainant
Lordship.
and molested her. But whatever the nitty-gritties are not
Lordship, sir.
required.
Yes, Lordship.
So the complainant was the lady and he has denied all the charges.
Lordship.
Correct. Now, if it is a case of her word against his word, then obviously forget beyond reasonable doubt, even by preponderance of evidence, it cannot be said that the charge is established. But forget that. What I am asking is, the inquiry officer has recorded a finding that these things are proved. Where is the evidence to prove that? What is the basis on which he arrived at that finding? If there is no basis, then this finding is perverse. If it is perverse, then the inquiry report goes. The inquiry report goes, the charge will go. Forget what happened in Paul
Lordship.
McAntony and GM Tank and all this.
This is separate thing. Yes,
But
Lordship.
on the facts of this case, where is the finding?
Lordship. And even then also, Lordship, when the incident has been reported against a, so it is always the authorities are duty bound to look
punish.
into this,
To
Lordship.
punish.
And one more thing,
Authorities
Lordship.
are duty bound to do it. The courts are duty bound to see whether it is
Yes,
correct or not.
Lordship. It is always there,
Are you
Lordship.
defending this or not? Tell us that. If you are defending, then we'll hear your arguments. What is your argument? If you are not
Lordship.
defending, then I'll dictate the judgment. My simple question is that,
Yes, Lordship.
let us assume that everything is correct.
Lordship.
Complaint filed, inquiry initiated. But once a charge sheet is submitted, inquiry
Lordship.
proceeding is held, the charge has to be proved by preponderance of probability. Here, nobody has seen anything. It's the word of the complainant against the denial of the molester, let's call him for now, or the petitioner. So that means the charge is not proved. If the charge is not proved, penalty is unsustainable. Apart from that, criminal trial, he has got acquittal.
But acquittal also, this is on the point of benefit of doubt.
Maybe, but there is no
Benefit
appeal.
of doubt, Lordship, always, because they could not prove it. That's why the benefit of doubt, Lordship.
But actually, he has done it. Is that what you are saying? That is the
Because-
emotional argument.
No,
not the
no,
legal argument.
Lordship. This is because,
We have to go by the law.
yes, Lordship, there are law, Lordship. If there is nothing here, while the judgment has been passed, Lordship, this is not that some sentence has been used that always the accused are given benefit of doubt. This is there. The word is there.
That's fine, but he has been acquitted.
Acquitted, that means mere acquittal does not that means
Does not prove he is innocent. All right, I accept it. All right. But then the penalty has to be based on the inquiry report, which must have a reasonable basis to show that the charge has been proved. The only question I am asking you is that findings recorded in clause 2 and 3.
Lordship.
What is the basis of this finding? There may be some basis. If it is there, you show us. If there is a basis, then we'll say that the charge has been proved and the matter ends here.
Yes, Lordship, in page 44, it is there
44.
that in the story of the prosecution, a prosecution could not prove the case beyond reasonable doubt. It creates serious doubt regarding the story of the prosecution and the criminal law. The doubt always gives benefit to the accused person.
That's correct. That's the criminal judgment. That is on benefit of doubt.
Yes, Lordship.
But if there is doubt in the criminal case,
But
that
the
doesn't mean.
departmental proceeding is also on the independent findings, Lordship. This is on the.
Correct. So what I am asking you is,
Yes, Lordship.
show us from the inquiry report, what is the
Lordship.
basis to hold that the charge has been proved?
Lordship, kindly allow me sometime, kindly take it up on tomorrow, Lordship. I'll just go through again, Lordship, and I'll appraise. If I'll not, Lordship may dictate it, Lordship. Lordship may post it tomorrow.
That can be done.
Yes, Lordship.
But have you understood the point?
I understood, Lordship. That's why I just want to go through again, Lordship.
If you can show that there is some material
Yes, Lordship.
for the inquiry officer to arrive at this finding,
Yes, Lordship.
then we will stay our hands off it. But if it is totally without any material, then this finding will have to be termed as perverse in the eyes
Yes,
of law.
Lordship.
What is perverse? A finding arrived at without the evidence or contrary to the evidence. If it is without the evidence, it is perverse. If
Yes,
it is
Lordship.
contrary,
Contrary.
evidence says right, the finding is left,
Yes,
it's
Lordship.
perverse. And perversity is a question of law, as you
Lordship.
know. So on that ground,
Yes,
the
Lordship.
inquiry report will have to go. And if that goes, the order of
Yes,
penalty
Lordship.
will have to go. What?
But regarding the presence, the monomodulary, in page 66, well,
Page 66.
yes, well, PW2, in whose quarter she was there. The next parameter, 66 PW2 next para. In her cross-examination, she stated that she did not see any incident. She went to the house of 13 May, Sunday. Her house is at Kokrajhar as so and so. On 14th May, she was in her quarter. The court questioned whether Anjali Karji and her husband was present in the quarter. On 14th May, she was present, but husband was not present. He did not have any premises for SP to keep Anjali in her quarter.
That's fine. What difference does it make? He
Yes.
also said,
Yes.
your client also said that on that day, on 13th, she was not there.
Yes.
And on 14th, he was there. So
Yes.
what see, going here and there, please give it in type tomorrow.
Yes, sir.
We'll have it tomorrow then
Yes,
as
sir.
fixed part and matter. Hard in part, so and so, hard in part. On the request of Ms. N. Bhattacharjee, learned additional senior government advocate office to use this case again for hearing tomorrow as fixed part and matter.
Obliged.
So what is the rising time of the court today? Mr. Saikia, the court will rise in 10-15 minutes. What is your matter?
The petitioner was registered in service after departmental inquiry, and the board of directors held that none of the allegations are proof, so he was registered in service. But after some years, another managing director came, and he held that the earlier order of the managing director was wrong. So he, my lord, passed the order, imperial order, that the salary which he has during the suspension period, he will not get the salary. That is the case.
Your client is in service now.
He is now retired few months ago.
He is retired. So the issue is whether he will get salary for that period.
Yes, suspension period.
So how much time will you take to argue your case?
Well, I will say take it on Friday or on Monday, because it will take some time, because I have to read some of the orders passed by the
So
High
the
Court.
court is rising at 3:15 today. You must have seen.
let it be taken up in the next week.
Next week. Due to paucity of time, the hearing of this matter was not possible today. As such, on the request of Mr. R.C. Sekal and counsel for the petition, office to list this matter for hearing again in the next week.
Obliged.
Mr. J.K. Goswami and an additional senior government advocate Assam is present on behalf of the state. The last matter?
Dismissal from service.
It will take time.
It will take time. I'll have to take your lordships to the evidence. Violation of natural justice as well as perversity, my lord.
So the bench,
Take time.
court is rising
I
early
understand,
today.
my lord.
And I'm told this bench is not available from next week. I'll be
Lordships.
sitting in a division bench.
Lordships.
So that's why I don't want to make it parted now. You do it next week then.
Lordships. I'll try my luck.
If a debt, my lord, can be fixed.
Huh?
If any debt can be fixed.
Debt.
Debt.
What debt you want?
Definitely. Convenient to the court and my learned.
He is out of service.
Out of service, dismissal from service.
If it can be fixed on.
See, the problem is if I continue in the bench, I can put in 5, 10 matters, but I don't know
understand.
which honorable judge will be taking up this roster.
Lord, can it be subject to availability of your lordships, my lord? After vacation or in the month of December, if your lordships is available in bench 3?
December, this bench is not available. After
January, my lord.
After vacation.
After vacation.
Yes, my lord. No
All
problem.
right. Can you decide on a date?
Or January. 9th is a Miller Thursday, hearing day.
My lord, there will be some difficulty on my part, my lord. If it can be after BU vacation on 21st.
21st, my lord. Fine.
21st January.
All right.
Most obliged.
Due to paucity of time, this matter could not be heard today. As such, among the request of learned counsel for both the sides, this writ petition is directed to be listed again on 21st of January 2025. In the top of the list in hearing items. Over naam di dibo, so and so forth, so and so, so and so. Top of the list 21st.
Can it be taken up as if it can be taken up as part heard or further hearing?
No, part I can't, I don't know. January, you don't know who is going to be where, what is happening, and your client will get stuck up unnecessarily.
Yes.
21st January I've given, and
Right.
let us see what happens.
Lordships.
Because next 1 or 2 months, there will be a little turbulence. Let's not say more about it.
Lordships.
If you get a matter stuck up, then it will be difficult for you.
Yes.
So take a call. But I've given it top of the list, first item.
Yes, my lord. Much obliged.
I can also add that considering the fact that the writ petitioner is out of service, it is made clear that no prayer for adjournment will be
My lord.
entertained on the next date.
My lord.
That means the matter will have to
Yes.
be heard,
Yes.
whoever the bench is.
Yes, yes.
That much assurity you have now.
Much obliged.
On earlier occasion, my
Much-
learned friend, they have taken time. I have not taken time.
But that's all right. Because it is a dismissal from service, so
Yes, I understood.
2023 matters will be heard.
Yes, ma'am.
Anything
Much
else?
obliged.
Then I'll rise.